Barry Otterback. It's about 3 minutes after 9 o'clock, and we are now in session. This morning we have 5 cases. The first case is a combined appeals, followed by conditional use permit, 2 variances, and finally we're going to wrap up with another conditional use permit. Those conditional use permits and variances are going to follow the appeals case. So if you're here for those cases, you're going to be in for a little while. You may want to take a break and come back in a little bit. For the appeals, we have a proposed procedure list, and here in a minute I'm going to ask that we get a motion to adopt the proposed procedures for the appeal case today. We will maintain civility and respect throughout the entire meeting today. There will be no profanity or disruptions from anybody in the audience. The appeals is an appeal to an administrative decision only, and that is all that we will be talking about throughout the appeal case or cases. We're not going to talk about any other part of a data center or anything else. This is purely an appeals process to an administrative decision. Board members, everybody should have received a proposed amendments to the proceedings for the appeals. Are there any amendments to that? And if not, I need to get a motion to accept those proposed procedures.
Make a motion that we accept the procedures.
Thank you, Charles. Any discussion?
A second.
Thank you, Bill. All in favor signify by saying aye.
Aye.
Aye. Those opposed? They've been adopted for today. I will go ahead and, Anna, if you want to put them up on the back screen, I'm going to explain how today's going to unfold, or at least the this appeal. Thank you, Anna. So here in a minute, I'm going to swear staff in, and then Mark is going to give us the report, or an introduction of the application. Staff is going to come up and give us a staff report to the board. There's going to be questioning by board members to staff, and when we're done with that, staff's going to take a seat. Then the planning director is going to come up and give us, justify his decision, and he'll have 20 minutes to do so. There'll be questioning by board members to planning director. The clock is on the wall. I'll explain that here in just a second. Christie's in charge of the clock. Following the planning director, appellate Rob Houchinson will come up and give his presentation. He'll have 20 minutes to do so. There'll be a round of questioning by board members to appellate Houchins. When we're done with that, presentation by appellate Lampton will come forward. She will have 20 minutes to do her presentation. There'll be a round of questioning by board members to that appellate. And when we're done with that, she will take a seat, or those representing her. And then finally, the appellates of Oberg and we are Oldham County, same thing. We'll have 20 minutes to come forward and give us a presentation. Same thing, there's going to be a round of questioning by that appellate, by the board members. And when we're done with that, that member will take a seat, or those representing that appellate. When we're done with that, everybody wishing to speak in favor of the appeals will have 10 minutes. That is collectively, you'll have 10 minutes. Okay, so everybody wishing to speak in favor of the appeals, everybody collectively has 10 minutes. That means if there's a bunch of you that want to talk and one person gets up and talks for 8 minutes, there's only 2 minutes remaining of that 10-minute block. Okay? So collectively 10 minutes for those wishing to speak in favor. Following that's a presentation by Western Hospitality, 20 minutes. And there'll be a round of questioning by board members to Western Hospitality. And when we're done with that, those wishing to speak in opposition, same thing as those who spoke in favor. Collectively, you'll have 10 minutes. Okay? Same thing. Following all of that, there will be 5 minutes for rebuttals. It starts with the planning director, 5 minutes for Houchins, 5 minutes for Lampton, 5 minutes for Oberg and we are Oldham County. Those are all the rebuttals. You'll have 5 minutes each, and then 5 minutes for Western Hospitality. Final statements. No new testimony during final statements. Likewise, or same, you'll have 5 minutes, starting with the planning director, and then Western Hospitality, and then the appellates, Houchins, Lambton, Oberg, and Weir Oldham County. All will have 5 minutes each for final statements, no new testimony. When we're done, there's going to be any questions by the board members to anybody in the audience. And when we're done with that, I'm going to close the floor for public comment and public hearing, open it up for discussion among board members, and I'll call for an up and down vote. All right. With that, let's swear staff in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay. All right, Mark, would you like to read the item on the agenda here?
Oldham County Board of Adjustments and Appeals, docket number OC 25020, 21, and 22, administrative appeal. A combined hearing for application filed by Robert Hochkin, Nate Lambton, and Weir Oldham County, Nathan and David Oberg, requesting an appeal of an administrative decision concerning the determination of private utility for data center use in property located at 3557 North Highway 53, LaGrange.
Thank you, Mark. Anna?
Good morning, Anna Barge, Senior Planner. Today I'm going to discuss docket numbers OC-25-020, 021, and 022. This is an appeal of an administrative decision for the property located at 3557 North Highway 53 in LaGrange. So the proposal we're hearing today is a combined hearing for the applications filed by Robert Houchins, Nana Lambton, and We Are Oldham County / Nathan and David Oberg, requesting an appeal of an administrative decision concerning the determination of private utility for data center use of the property located at 3557 North Highway 53 in LaGrange. This site information, the zoning is AG1, agricultural, and CO1 conservation. The land use is undeveloped. The acreage is 267.29 acres. For the site history, a technical review committee application was submitted by Western Hospitality Partners, or WHP, on March 19th, 2025 for Project Lincoln, who was given the docket number TRC-25-007. WHP subsequently submitted a conditional use permit and variance application to be considered at the Board of Adjustments. WHP has since withdrawn both applications for the 3557 North Highway 53 location. For the case history, and now this is case history for the appeals applications, not for anything else, just the appeals applications. So for the appeals applications, the agenda was posted to the planning website on May 29th, 2025. Adjoining property owner notices were mailed on June 3rd, and the public notice appeared in the Oldham Era on June 12th. The property in question today is outlined in red on this map. We have the zoning map here, and you can see primarily the property is zoned AG1 with conservation zoning on the north and southern portions. And then for the rest of the area, there's AG and CO1 zoning, as well as residential, various types of residential zoning throughout the area. For the notes, there are 3 appeal cases being heard today. The first appeal case was submitted by Robert Houchins on May 1st, 2025, appealing the following as stated specifically in his application. Accepting application for conditional use by Western Hospitality on grounds that data center is not specifically listed as a conditional use in AG1. The second appeal case was submitted by Nana Lambton, represented by Strobo Barkley, on May 19th, and is appealing the following as stated in their application: official action, order, requirement, interpretation, grant, refusal, or decision that interprets the proposed hyperscale data center development as a private utility building and facility. Additionally, on their application, they stated that the determination of the private utility buildings and facilities includes the proposed data center at 3557 North Highway 53. The third appeal was submitted by Nathan Oberg, David Oberg, and We Are Oldham County, LLC, represented by Hank Grady on May 19th, 2025, and is appealing the following as stated in their application. Consent to proceed to technical review committee with data center in AG1 as private utility. According to section 350-030 of our zoning ordinance, an appeal must be submitted within 30 days after the appellant or their agent receives notice of action of the official. This must be done by filing with said officer and with the Board of Adjustments and Appeals. Lastly, please refer to the applications and letters from the appellants included in your packets for additional information. On June 4th, 2025, our attorney's office, Vaughn Pettit, notified the appellants, Western Hospitality Partners, and Director Fisher of the following: the date of the Board of Adjustments meeting, the procedure of the appeals that will be recommended to the Board of Adjustments, the withdrawal of the WHP applications at the 3557 North Highway 53 location. So included in this letter was our intention to recommend to the Board of Adjustments that the appeals be denied as moot and to advise the BOA that any appellant who wishes to continue contesting the acceptance of WHP's new applications should submit new appeal applications. And lastly, if they would like to submit new appeal applications, they can contact me, Anna Barge. On Thursday, June 5th, Robert Houchins emailed me notifying of his wish to transfer my appeal to the new application for the same applicant, but on a different location. That same day, I responded via email to Robert Houchins stating you will need to withdraw your current appeal and submit a new appeal for the new location. The new appeal will not be heard at the June meeting as we are long past the deadline. This is because we have to send adjoining property owner notifications, so there's no way you can just transfer your appeal to new location without submitting a new application. So this is that email. We start down here where Robert Houchins emailed me on June 5th. He said, since the appeal applies to the application that was for the site on 53 and my appeal applied to that site and all the issues are the same, I wish to transfer my appeal to the new application for the same applicant but in a different location. What do I need to do to formally make this change? And this is what I just read to everyone right here. Now, this is the section that covers our appeals process. In our ordinances, note that such appeals shall be taken within 30 days, and you have to be injuriously affected or aggrieved. So the considerations from the staff's perspective, there's two things that I'm going to talk about today. First is, are the appeals timely, and are the appeals relevant? Starting with timely. So this is a letter from Strobo Barkley. They reference a letter that Western Hospitality Partners filed with their technical review committee application. And they stated that this letter was not publicly published on the planning and development website until on or about May 1st. We know that that's blatantly false, and I will show you that in the following slides. They additionally said that the client has received no notice of official action, order, requirement, all of that as a qualification under AG1, defined as private utility building and facility. So this is a letter from Hank Grady, Nathan and David Oberg, and We Are Oldham County LLC's legal representative. It's interesting because they're appealing the allowance of WHP to go to technical review committee. His appellants were both sent notifications for both the April and the May technical review committee meetings. These notices were mailed to the appellants, David and Nathan Oberg, on April 1st and May 2nd. So the agendas were posted, the April agendas were posted on the website on March 31st. This screenshot is from the YouTube video, like the one being streamed today. From the slide from a Board of Adjustments meeting in April, stating that agendas were posted to the website on March 31st. Additionally, I have evidence here where Director Fisher, and that says Monday, March 31st at 12:44 p.m., sent the agendas, including the technical review committee agendas, out on March 31st, including Project Lincoln. So our wonderful Magistrate Woosley posted, he's really great at sharing agendas for everyone and getting the word out for us. He posted in the private Facebook group for We Are Oldham County on March 31st. Here is the agenda for Wednesday, April 16th, TRC meeting. And he also shared the link to where our technical review committee's items are posted. He said it has the application plan and legal notice, and here's that Project Lincoln Data Center. Additionally, Melissa Vasher posted on the private Facebook page for We Are Oldham County on March 31st, posting the actual legal note that Strobo Barkley said that we did not post until May 1st, which they are clearly wrong. So on 2 items were removed from the technical review committee agenda on or about April 4th, Project Lincoln and Parkwoods Townhomes. So once those were removed, we posted the updated agenda on our website, and then we removed those 2 items with their content off the website because we don't want to confuse people and make people think they're still on the April agenda. And Adam Smith posted in the private Facebook group for We Are Oldham County on April 4th, tagging Nathan Oberg that stating that the technical review committee item for the Project Lincoln Data Center had been postponed, so they were aware that it had been postponed to May as early as April 4th. And you can see here where he posted that agenda right here. Now on to, are the appeals relevant? So on Monday, June 2nd, Western Hospitality Partners withdrew their technical review committee application, or technical review committee conditional use permit and variance applications for the 3557 North Highway 53 location. On the same day, they submitted a technical review committee application and a conditional use permit application for the 3210 D.W. Griffith Lane property, a property zoned industrial park district. All 3 appeal applications specifically mention the 3557 North Highway 53 location and AG1 zoning. Things that don't apply to the plan being considered now. So I'm going to go over each appeal application and show you where they directly apply to the North Highway 53 location and AG1 zoning. Starting with Robert Houchin's appeal, this is from his application. He has the North Highway 53 location, the parcel number for that, AG1 zoning, and the lot size. He also references AG1 zoning in his letter. For the Nana Lambton appeal, they have that address right here, the parcel ID, AG1 and CO1 zoning, and they specifically mention the North Highway 53 location here and AG1 zoning. Additionally, in their letters, they have AG1 zoning here, and the Highway 53 location there as well. Lastly, for the Oberg and Oberg application, Project Lincoln was not required to go to technical review committee. But Director Fisher requested that the applicant go through the technical review committee process. Project Lincoln followed the process that we requested. Next, Oberg and We Are Oldham County specifically mentions the North Highway 53 appeal in their application and that AG1 zoning. Here's that parcel ID, the acreage, and AG1 right here. Additionally, in their letter, Hank Grady states that Nathan and David Oberg are property owners adjacent to the Project Lincoln subject property. We know that's no longer true. Here is this address. And then here is the North Highway 53 address. And I apologize if this is repetitive. It's just with the 3 appeals, AG1 zoning. So now I'm going to go into the summary process. I'm going to summarize each of these 3 appeals because they are 3 different appeals. So for Robert Houchins, his appeal is not timely, as notice was posted on the website for the technical review committee for the conditional use permit on March 31st. His application was submitted on May 1st. That's beyond 30 days. His appeal is not relevant as it specifically references AG1 zoning and the property located at 3557 North Highway 53. The application for this location has been withdrawn. The new location is on D.W. Griffith Lane and is zoned Industrial Park District. This is basically the same thing for Nana Lambton appeal summary, except they didn't apply until May 19th. And Oberg and Oberg also applied May 19th, which is 2 days before the technical review committee meeting. Additionally, technical review committee was not part of the required process, and no decisions were made there. Thank you.
Okay. All right, any questions for Anna? Okay, thank you, Anna. Are you here representing Rob? Okay.
I just want a point of clarification real quick. I'm not going to ask any questions, just a few procedurally, if that's okay. So I want to be able to cross-examine Anna. Can I do that now during?
No, not at
That's
this time.
typically when we would do it, when she's here. So I want to make sure that everybody understands when they're cross-examining witnesses. So when can I cross-examine the witness? Because I certainly have the right to do that.
My recommendation would be that that happens during the presentation by the appellant.
That's problematic because that cross-examination can last a long time. And my understanding is typically how this board functions is that we can cross-examine witnesses after they testify.
Well, she's just given her testimony, her presentation to the board. I think you've heard that. You have the opportunity to present your case how you see fit during your presentation. You also have an opportunity for rebuttal. I think that is adequate. It's an opportunity to be heard. It's an opportunity for cross-examination. How the appellants use their time is up to them. And so that would be my recommendation to the board. I think that was what was communicated to all of the parties in the letter that we sent to them explaining what the recommendation for the procedure would be for this hearing, and I would stick to that recommendation.
Okay.
That's not my common understanding of how this board functions. And the statute is clear that we all shall be given an opportunity to be heard. So if you're denying me an opportunity and the time to cross-examine a witness, that's a due process violation, and I wouldn't recommend you do that.
Okay. We're talking about giving time during the rebuttal process.
I mean, they have time to present their case, whether it's in their presentation or in their rebuttal. How they use that time is up to them. If they use it to cross-examine witnesses, that's perfectly acceptable, and they're free to do that. They have to be given the opportunity to be heard. I think they are given that by the procedure that's recommended and has been adopted by the board. I do not believe there's any requirement that we set aside additional time specifically for cross-examination. I also note that the board is may, at its discretion, extend the time limits if it sees fit for any presentation or aspect of the procedure that's been adopted by the board. And so I don't see this being a due process violation. The board is free to control its procedures so long as it provides an opportunity to be heard, and I think this does that.
Okay. So could we also do it in time of those who wish to speak in opposition or in favor?
I don't think that's what that time was intended for, but the board is at,
So during the rebuttal process or time of the appellates?
That would be my recommendation, yes. And I think that's what was intended and communicated to the parties coming into this hearing.
And Mr. Chair, I have a few questions. I mean, I'm not going to take 20 minutes. It'll be like 4 or 5 minutes with Ms. Anna. I guess I would ask then that the chair, if this is the way you're going to rule, I would ask that you would give us an extra probably 10 or 15 minutes during our presentation then, since we're not allowed to cross-examine here, to give us a little bit more time to cross-examine. I'm not going to, I have some questions for Ryan. I have some questions for Anna, but I'm not going to be there too long.
Okay.
And I anticipate, based on what Mr. Fisher testifies
I'm
to.
going to follow
but,
our counsel's recommendation, and we can do it during the appellate's, either the presentation or the questioning during the appellate's time.
So I'm going to ask you now then for extra time during our presentation of about 15
We can
minutes.
do that when the time comes.
Okay, thank you. So you're denying me the right to cross-examine her now?
For now, that's
Okay,
correct.
thank you.
All right, presentation by appellate Houchins. Oh, did we? Oh, I'm planning director, I'm sorry, planning director.
Mr. Chairman, I'm Keith Brown with Pike Legal Group, P.O. Box 369, Shepherdsville, Kentucky, 40165. I represent Planning Director Fisher, and what we thought we would do, if it's okay with the chairman, is that Mr. Fisher would explain his interpretation for a number of minutes, and then I have some legal arguments that I would make after that. But Mr. Fisher is anxious to make his presentation and to be very transparent about his decision.
Okay. That's fine. Ryan, If you'd like to, were you sworn in?
Yes.
Okay.
All right, Ryan Fisher, Oldham County Planning Director. So I'll tell you a little bit how we got to this point, and a little bit based on the decision that was made on the private utility designation. So this kind of started back either late December or early January. I was approached, I think after the course of another hearing. It wasn't any sort of formal meeting or anything, by Mr. Ashburner, as well as Mr. Urban, and ask about what we would consider a use for a potential data center. I, of course, like many probably through this process, said, what is a data center? And so I kind of started my research at that point. We did meet twice, actually in a meeting that was scheduled at the end of January, on January 24th, as well as February 10th, 2024, where I told them that my final determination at that point was that it fit closest with the private utility designation. And I made that decision based off several different things, one of which, going into it, had no clue what a data center was, and even to the scale of what the proposed data center was on Highway 53. So the first thing I did in the course of my investigation was reached out to an email group that we have with a bunch of different planners throughout the state that we're always throwing, questions out to say, hey, how do you guys do this? How do you people do this? And so I'll put these up on the overhead. I know they've been submitted already. I don't know,
Jay, can you get the overhead, please?
So my email here to this group, and number 2 doesn't really pertain to anything that we're talking about today. But I just sent out, data centers are a hot topic in our area and around the state. We do not have anything as far as permitted or conditional uses for quote unquote data centers in our regulations, which I soon found out no one does in the entire state. What is everyone else classifying these as, or have you all been proactive and added the term data centers to your zoning regulations? So keep in mind, we're talking about question 1, because you're going to see responses in here for the second question that I also had that particular day. So Barron County, we don't have anything for number 1. Number 2, from Brian, and I can't remember where Brian is from. I'd have to go back and look at that email. Nothing has been addressed in our zoning ordinances so far. The bottom of the page, Bullitt County, said Bullitt regulations currently list data processing centers as an allowable by right, and that's going to be important, in the B1 Highway Business District, with the definition of a data processing center likely being different than in 1987 when our regulations were adopted. We will seek to adjust this in our upcoming major revision of the regulations. I suspect it will be adjusted to IL, light industrial, or a new commercial zone created. Prospective clients that have reached out to us actually agreed that light industrial was more appropriate, at least verbally. And that's from Charlie Spalding at Bullitt County. Brian Davis from Metro Louisville. We use our super antiquated listing for telecommunications hotels to allow data centers in our industrial districts. Now, at the same time, Louisville had a proposed data center that came through, which actually was just approved yesterday from their local development board on a vote of 4-0, with not a whole lot of opposition, and that was permitted by right within that area. It didn't require any zoning change, anything of that nature. So they use this telecommunications hotel characteristic. Owensboro, our ordinance allows computer data and business processing centers and call centers in our professional, business, and industrial zones. And then lastly, Lise Ketz from Georgetown, our ordinance does not define data centers. We do allow for data processing and call centers in our business park and limited light industrial, including but not limited to research, experimental, or testing laboratories in our general commercial park zones. Other zones do allow for warehousing that may be interpreted to include data centers, but we've not been prompted to make a determination on this matter. So really, at the end of the day, they didn't provide me much help at all on what I could classify data centers as based on our regulations. And in our regulations, I will note Louisville's telecommunications hotel, we don't have that in our regulations. There was another one on there, and I don't think I read it, but they said they classify data centers as warehousing. So the other thing that we do when we don't really have a specific definition for anything is we consult the APA Planner's Dictionary. Well, of course, the APA Planner's Dictionary also doesn't really get into defining data centers. Now, they do have telecommunications hotels, which is similar to what Louisville uses. Telecom hotel is defined in the APA Dictionary. There's a telecommunications carrier facility containing equipment for telecommunications use, including switches, routers, operation centers, and other infrastructure critical for .com companies, internet servers, data firms, fiber optic cable, and other technology providers. So that's the definition provided there. So then the next place I look is obviously our zoning regs, which is what I am tasked with interpreting. And this is something that literally in our office we do, if not weekly, we do it daily. We get calls from individuals that are looking to buy property, whether it's for a commercial use or anything, and they want to know, based on what this property is owned, can I do a particular use? So this is something literally our office does daily with individuals, whether in meetings or by phone call. We get calls from realtors that ask the same questions. We literally just had one 3 days ago from a gentleman that called and wanted to do an operation that would take logs that were picked up from sites, brought to this facility that he wanted to operate, which then he wanted to convert into mulch and sell other natural products on his property. Well, guess what is not in that zoning classification? Mulch making factory. It would be nice if there did say mulch making factory. It would make my job a whole lot easier. But what myself and our office is tasked with doing is to try to find the best use based off of those uses that are in our zoning regs to see if it complies. And our office does that literally, if not daily, weekly. We do that all the time. And that is my job as a zoning administrator to look at our current zoning regs and to figure out what applies or whether or not a zoning change needs to be done. So in looking at our regs, as they asked me this and we met and I reached out to other planners throughout the state and it didn't really find much help there, I looked at what our private utility definition is, because my first thought was, well, private utility seems to fit the most on this. And so our private utility definition in our zoning regulations, okay, which I'll keep in mind, that's what I'm tasked with interpreting, our local zoning definitions. A private utility is defined, and I broke it down into 3 parts because anytime I want to take a definition, I'll take it and break it down into parts. And so the first part of that private utility definition is any system, facility, or building. Okay, well, I think we can agree that this data center that was proposed is a building, okay? Number 2, it's operated by anybody other than a municipality, government agency, or public utility. And then the third point is it's deemed necessary for public health, safety, and welfare. So as I researched more into data centers, what I realized is that from the time we wake up in the morning to the time we go to bed at night, we access things from the cloud and from data centers. From the time we wake up, and this is something that I did not know back in December, but from the time we wake up, the news we stream online, the Zoom meetings that we have to get on for work, our medical records now on my chart are all housed on a server in the cloud. The music we stream, the map that we use to get to our destination, if people use that to get to this location a day for the meeting, all housed in a data center. And we can sit and make the argument that we don't know the end user and we don't know that. I don't know how many times in the process that we've been going through to create regulations have I been sent regulations that have been created through AI. So even if we make the AI argument, AI and ChatGPT have come in quite handy for people sending me recommendations for what I think a data center regulation needs to have. So no matter what the use is at the end of the day, that is something that throughout the course of a day, we rely on information that comes from the cloud. that comes from a data center in the daily course of our day, the same as I would if I flick on the light switch, the same as I would if I flush my toilet, or anything else that we would use that people would consider a public utility. So my determination in that point was then made based on private utility was the closest designation we had. I was also confident with that decision because the private utility would require a conditional use permit. What I didn't want to do was to find a use that would require no hearing at all, which is really what Louisville's was permitted by right. You heard a couple other zoning administrators comment that they had certain classifications that data centers would fall in, even though probably antiquated listings, that would be permitted by right. When you're permitted by right, there's no hearing at all. There's no hearing before you all as the Board of Adjustments. There's no hearing before the Planning Commission. There's none at all. So I was confident in that decision would at least require it to have a conditional use permit, which would come before you all as the Board of Adjustments. Who can make a competent decision on a conditional use permit? And the state law requires that you all or the board to hear that conditional use permit. I also, Anna mentioned in her presentation that I recommended they go to TRC. I'll take that a step further in that I told them I would require them to go to TRC with this process, which would then give it a second public hearing, which is something that we don't normally have conditional use permits go for. Now, we have the right to make them do that. But I told them specifically in this case, because of the nature of it and because of the nature of, the talk about power, we would want a TRC hearing where agencies could hopefully be represented and give us answers to this thing that literally not many people in our state know about. So I required them to go through 2 hearings, TRC and then ultimately a Board of Adjustments case for their original case on 53, and we're making them do that on their current case that's listed on D.W. Griffith. So for those reasons, I'm confident in that decision of private utility, that it would have ran its course through the process had it gone that route, and there would have been public hearings and there would have been public involvement. So I think that's all I've got.
Okay, anything else?
Yes, Mr. Chairman. Again, Keith Brown here on behalf of Planning Director Fisher. Obviously, Director Fisher can speak very well for himself, and I think he's given a very good explanation of his decision. I have a few comments to make. I ask you to think about the level of due diligence that he applied to his decision. Everything he looked at, everything he considered, and how he reached that decision, breaking down all of the provisions of the language of the definition. That is what a public servant is supposed to do, and that is the kind of decision that I think you should affirm and reject the appeal. I wanted to go back to some of the comments that Anna had made, which are very important. Anna documented that these appeals are untimely. And what that means is that this board does not have jurisdiction to hear them. So what I'm asking you to do is at the end of this proceeding, deny these appeals as untimely. You all will recall the letter that Anna was kind enough to put in your board package that I submitted last week, giving more detail on some of these legal arguments. But Kentucky law very much applies strict compliance to these appeals, to statutory appeals. And if there is not strict compliance, then there's no jurisdiction for the appeals. I've litigated cases on these issues for 30 years. I hate to say how old I am, but I've litigated many cases like this, and the law starts with a case called Board of Adjustments versus Flood, and I cite that in my materials, and there are many cases following on to that. What all those cases end up doing is applying the strict compliance and dismissing various kinds of land use appeals if the timeliness was not there, okay? So that's one reason to deny the appeal. Another one is simply what else Anna talked about, that it is moot. These appeals were all referenced as to the original property address. They're not appeals that can continue to survive when that application was withdrawn. a requirement of any of these appeals is that a person be injured or aggrieved. They allege they're injured or aggrieved. There's no way these parties can sustain that burden that's in the statute and it's in your ordinance of injury or aggrievement when they're appealing something that has been withdrawn. So that's a second independent basis for denying these appeals. Also, I want you to consider the broader issue of that you may be opening the floodgates of allowing interlocutory appeals, which is what we lawyers call these interim appeals before a final decision say of a circuit court trial or a final decision on a CUP. As Ryan mentioned, he has many times over the course of a week where he will give various interpretations to people calling his office. Given the publicity of these appeals, the consideration of these appeals, and if they were sustained, that would encourage anyone who had any issue with any interpretation that Ryan made to file basically an interlocutory appeal and try to run this up through the BZA and then maybe on to circuit court before there was a final decision on the CUP itself or on the variance itself or on the rezoning itself. So be careful as a policy matter what you're doing here. The granting of this appeal has broader implications than just this case. The definition that Ryan read, I'm going to read it again because I want to make a one more point on it here. Okay, in the Oldham County zoning ordinance, the definition of a private utility building is any system, facility, or building that is operated by other than a municipality, government agency, or public utility, providing to the public a service deemed necessary for the public health, safety, and welfare. Well, Ryan reasonably concluded that the proposed data center fit into that category. I want to read to you a short Kentucky statute, which is KRS 278.546, which I quoted in my memo. That states, state-of-the-art telecommunications is an essential element to the Commonwealth's initiatives to improve the lives of Kentucky citizens, to create investment, jobs, economic growth, and to support the Kentucky Innovation Act of 2000. So that ties in very much in the definition of data center, the definition of a private utility of something that is deemed necessary for the public health, safety, and welfare. The Kentucky legislature has deemed telecommunication services essential. So that ties the statute to the definition of the private utility. And Ryan has just talked to us about how these data centers are tied into the internet, tied into telecommunications. So it's an essential part of the internet, telecommunications, and it is something that fits into the definition. Understand that what Ryan was doing here was interpreting a definition. He wasn't trying to rule on the merits of whether a data center is necessarily a good thing. He wasn't ruling on the conditions that should be in a conditional use permit. He was merely making one fairly narrow interpretation here, and he made a decision that was not arbitrary. That is key. In an appeal, you don't overturn a non-arbitrary decision. Thank you.
Okay. Before we continue, Board and Connor, we had just talked about cross-examination and doing it during the time of the appellates, extending their time, or well, we didn't talk about extending their time. However, everybody was given the proposed agenda, so the appellates, planning director, Western Hospitality, they all know the amount of time that they have. They knew that coming in here. Now we're talking about adding cross-examination during that time. Board, do you all want to extend the time from 20 minutes to anything else, add 5 minutes to that, or whatever, to allow for time for cross-examination?
I feel like this falls under the rebuttal. Maybe we can extend each of the rebuttal time periods by 5-10 minutes.
You want to do it during time of rebuttal?
I think that's the appropriate time, yeah.
Charles, what do you think?
I agree.
Time of rebuttal down here?
That's fine.
I agree.
That's
Okay,
fine.
we'll get to the extending time when appropriate. We will continue. So 20 minutes was it. Board, do you all have any questions for the planning director or
Yes.
representative?
Yeah, I've got one.
Yeah, go ahead, Mark.
Is if you hadn't been able to designate that the data center was a private utility, what is your where would you go next? I mean, how would you make a zoning change in the regulations to put data center in and make a definition in that? Or does that make sense?
No, repeat your question again.
Okay, since data center is not listed in the zoning, when you make the designation as a private utility, was there any way that you could have went back and changed the zoning regulations to add data center and put a definition on that?
Well, that's what we're attempting to do at this point. And this is very similar to, and this is something I didn't mention in the initial presentation, for years, okay, and you all heard many of these cases at this board. We had everybody that had a barn in the county decided they wanted to host a wedding venue at their farm. And so for a long time, we classified these barn spaces, event spaces, under a private club definition, which was a conditional use permit, which came before this board. That was not really a great designation for it. A barn that was hosting wedding events wasn't really a private club and didn't really fall within that definition. So what we did was we went and created a regulation for event spaces, and we put them as permitted uses in certain areas like commercial and industrial areas. And we had a conditional use permit if you wanted to try to do one in a residential area. So very similar to what we're doing now is, through our research, through, the process that we're going through right now in study review committee to try to determine what is the definition of a data center? What are we going to call these things? Where should they be put? That's the process we're going through right now so that in the future, we don't have this issue with trying to figure out, is this a private utility or not? So
Ryan, what is that process? What are the steps that you go through to change the definition and the regulations for zoning?
So in order to do any zoning text amendment, we have to start out with our study review committee, which is a subset of the planning commission. So it would be like a committee within state legislature or Congress or whatever. So typically in the zoning text amendments that I have been a part of, which have been short-term rentals, which have been solar panel farms, I'm trying to think what medical cannabis we went through. Typically, those processes take 2 to 3 months. We meet once a month, and typically those processes, all of them have gone about. Let me finish. Okay. I'll get there. Typically, those take about 2 to 3 months. So this coming Tuesday will be our third SRC meeting on our regulations, and it's my hope that they will be in a good enough position where those 6 study review committee members will push that ordinance recommendation forward to the planning commission for their meeting in July, and then hopefully get to the legislative body soon after that. Of course, we're a joint planning commission, so all of those regulations have to go before Oldham County Fiscal Court. They have to go before City of LaGrange. If City of Crestwood decides that they want to hear that, as well as Pee Wee Valley, we have to go to all 4 of those before the zoning text amendment truly becomes official. So that's the process now. We've met 2 months. This will be the 3rd month we've met, and so we're in the process and in a pretty good spot of getting some regulations in place to actually classify data centers in it.
So let me repeat what I just heard. So you have the study review committee would have meetings, then it would go to planning and zoning, and then it would go to fiscal court, and then it would go to whichever municipal jurisdiction may also have So it's kind of a four-step process.
And we would do all those legislative body ones with, they would run concurrently. We would be going to fiscal court. We'd be going to night meetings at LaGrange to try to get those, that same regulation passed.
Okay, thank you for the clarification.
How often do you come to something that doesn't quite fit any criteria?
How often?
Yes.
Weekly.
Okay.
I mean, that doesn't specifically have something that makes it real easy on me. And I mentioned the mulch making factory would have been nice, but that's not in there. So do we consider it millwork sales? Do we consider that retail and personal service establishments? The thing about uses in the zoning regs are those are usually very broad-based categories. So our zoning regs will say retail and personal service establishments and give a square footage. It doesn't say what you're selling. It could be anything. It could be anything. It doesn't get that narrow for us to be able to do that. So our job daily, weekly, monthly is to interpret those to figure out the best possible use.
Okay. Other questions for Ryan? Okay, thank you. If we could have Appellate Housins come forward, please.
Mr. Chairman, I'll be using the overhead, so if you could turn that on, I would appreciate it.
Okay, thank you. Jay, if you can turn the overhead on. And we need to get you sworn in, I
Please
believe.
You start my time when I talk.
Seriously. It'll be just a minute, please.
You can, that's fine. Thank you.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Name and address.
Rob Houchins, 1400 Jaeger Lane.
Okay.
Mr. Chairman, members of the board, I understand that sometimes that when you hear cases, some of them are clear, some of them aren't quite so clear. The reason I know that is for more than a decade, I sat on this board. I sat right there, and right there. I don't think I sat where you sat, Mr. Allen. But I can tell you for more than a decade, we had a lot of presenters come up. Some knew what they were doing because they've done this before and others haven't. Here's what I can tell you about me. My heart's beating faster standing here than it was when I was sitting there. So I'm not an attorney, but I'll do my best today, so please be patient. In the beginning of my case here, what we have here is an application for conditional use. For what? If you look down at the bottom, it says, for what purpose are you requesting a conditional use? Data center. It doesn't say private utility. I'm glad they were honest. I'm glad we put it up there at exactly what it is. It's a data center. It's not a private utility. Those words matter. And the reason those words matter is because you heard multitude of times already today, it was the best. It was the closest. And Mr. Allen, your question was right on about where the process was and where it goes. And so I'll try to answer some of that a little more technically. This is out of your regulations for Oldham County, and it's Division 020-040AG1. And under there, it says conditional uses. And conditional uses, it says community facilities and services. Now, I don't know about you guys, but if someone asks me where I'm from, I'm going to think, what city, what area, what community am I in? And when it says community usages, we're going to think the neighborhood I live in, the area or district I live in, the town that I live in. At most, I might say the county I live in. But what we're talking about, something here that is very local. The words matter here. Community is private utility, and you'll see more about this in just a minute. How did we come here? This is a little crooked. I'll get to use this. I'll learn how to use the overhead in the right way before we end here today. This is a letter from Dinsmore, and it's sent to you by Cliff Ashburner to Ryan. And this is how the application, this is how it was decided to use private utility, because if you look at the date here, March 19th. In the subject property, what we have here in the second sentence, the proposal is for the construction of a data center with 8 buildings under the comprehensive zoning ordinance. The use is best defined as private utility. and our client intends to file for a conditional use. So how was this come up with? Well, I can tell you how. It was suggested by a big law firm in Louisville. Now, this is out of the regulations, KRS 100.237. I know you guys have probably already looked at all this and getting prepared for this case. You would have seen my packet that I sent forward, and I referred to that in the packet. And hopefully you've read it. I'm sure you have. But I'm going to read the first paragraph. The board shall have the power to hear and decide applications for conditional use permits to allow the proper integration into the community of uses which are specifically named. Now, I don't know about your teacher, but when I was in math class or when I was in college, when they asked for a specific answer, they didn't ask for a general answer. They didn't ask for the best answer. They didn't ask for an answer that was close. When I was in third grade and I put down 5 plus 5 is 10, if I'd have put 11, I would have been wrong. Our conditional use process is very specific, and I do believe that they have to interpret down there all the time. I've seen nothing but professionalism whenever I've met with people in planning and zoning for the years that I was serving in your position, and I've not seen anything since that's any different. So for the people that have been down there, we were able to sit down and meet, and in fact, we were able to put regulations in many weeks ago and say, here are suggested regulations that we could use for data center. So here's what I'm saying. It says specific. Words matter. Conditional uses are limited. And that's why these words are in the KRS. And that's why they're listed here. And they're very specific. It says specifically named. While the administrator, while the staff down there must do what they need to do to interpret on a daily basis things like mulch factories when it's not specifically listed, I get it. I understand. But for the conditional use process, here's what we have to understand. 100.271, the administrator of zoning regulations and their powers. An administrative official shall be designed by the city or county to administer the zoning regulation. And if delegated housing or building regulations, the administrative official may be designated to issue building permits or certificates of occupancy for both, excuse me, or both in accordance with the literal terms of the regulation, but may not have the power to permit any construction or to permit any use or any change of use which does not conform to the literal terms of the zoning regulation. Literal. It's about specifically. It's about literal. Guys, look at your screens. That's what's in the zoning regulations right now about data centers. If you've paid attention to what's been... Got to keep my time, thank you, but got to keep my time. Here's what's, if you've been noticing what's been going on lately, what we've been talking about is putting a moratorium in place. I applaud the LaGrange City Council. They got it done. They put the moratorium in place. Unfortunately, our fiscal court was not so judicious. They did not get it done in a nearly timely basis. It's not been put in place. This is relevant today because if you rule against my appeal and the appeal of others, what can happen tomorrow is that the AG1 classification that you saw at the beginning that I put up here, and it says private utility, is in AG, CO, R1, R2, all the Rs, all the industrial, all the commercial. That means a private utility could be used to put a data center in every single acre of this county. I'm not here to protect me. I'm here to protect us. Now, I'm not as good as being able to quote a lot of the regulations, but what I'm going to do is I'm going to read some more of notes that I've prepared that apply to this application. So I need to read this, but you need to know whenever I reference a court case, it is a Kentucky court case. I have not used an attorney, but I've used some people to help me that aren't attorneys either, but this is what I've come up with. And this is what I hope you'll listen, because it's Kentucky court cases that are relevant, and I will quote them directly. The applicant claims that the proposed data center falls under private utility, conditional use classification. This classification is legally incorrect. The term private utility is not defined in the Oldham County zoning ordinance to include data storage centers or anything of the such, nor is there precedent in Kentucky law to stretch the meaning to encompass such uses. The Kentucky revised statutes, which I'll refer to from now on as KRS, are defining utility in KRS 278.010 subsection 3A as an entity furnishing regulated and essential services to or for the public. Courts applying this statute, including in the case City of Campbellsville versus Taylor County, emphasize the requirement of public use and service obligation. A private, for-profit data center serving closed corporate clients, Meta, Google, Facebook, AI, a number of them, is not regulated by the Public Service Commission. The Kentucky Public Service Commission is the regulatory agency that oversees these utilities furnishing essential services, such as electricity, natural gas, water, and telecommunications. Telecommunications, it's not the same. They don't have any 1.7 million square foot data centers that service telecommunications. These entities are granted special privileges and held to strict public obligations. The Public Service Commission ensures they serve all customers fairly, maintain safe infrastructure, and adhere to standardized rates and service areas. The proposed data center is not a utility. It has no duty to serve the public. It charges no rate. We won't get a bill from them. And it reveals no docket in the Public Service Commission when we did a request several days ago to see if there was anything listed under the Public Service Commission. I spoke with Linda Bridwell, the Public Service Coordinator, Executive Director, Public Service Commission Executive Director. She is also concerned that this has no regulation. This is not a utility as it stands. Therefore, there is no legal basis for treating this as a private utility. This classification is more than flaws. It is a misuse of the regulatory terminology to sidestep proper zoning scrutiny. You heard from this podium just a minute ago that we're trying to put regulations in place. That's all I asked for. Put the regulation in place and follow them, because what's on your screen is still that blank sheet of paper. You can't hear a variance from that. You can't say, oh, I'm going to let you be closer to inside the setback. You guys hear those kind of cases all the time. It doesn't apply here because you have a blank sheet of paper. In South Central Bell versus Utility Regulatory Commission, the element of service to or for the public is the distinguishing feature of a public utility. This was also a Kentucky case. In Griffin versus Shuck, zoning terms must be strictly construed. Under Kentucky law, the Board of Adjustments are explicitly prohibited from approving any application that would authorize a use not permitted in the applicable zoning district. KRS 100.243 subsection 3 says, in no event shall a Board of Adjustments grant a variance to allow a use of land, building, or structure that is not permitted in the zone in question. The use proposed by this application and the other one that's been applied, and that's why this is relevant. It's relevant because administratively he's made the same mistake twice. Not once, but twice. So what happens tomorrow when another application comes in? We know based on the LG&E that there are other data centers that are trying to come in and ruin this county. On American Beauty Homes Corp. Versus Louisville, the administrative bodies are creatures of statute and have only such powers that are expressly granted. We are not in this board and never has been a legislative body. You can't set the rules. You can't set up what the conditions are for something like this. It's massive. We're not putting little conditions of, oh, you got to put up a hedge. Oh, this isn't about, well, you must do this so that we grant you your variance, but you got to do this little thing. This is massive. This is much bigger than anything that's ever come before this board. We're talking about investments that are larger than any's ever been made in the history of Kentucky. Lastly, here on this point, I want to say this. In violation of the comprehensive plan, that's what we're talking about here as well. The proposed data center does not appear in any plan map, future land use recommendation, or economic development goal. In Bolin versus the Board of Adjustments, conditional uses must be evaluated within the framework of the community's comprehensive plan. It is inconsistent with stated objectives for compatible development, environmental balance, and infrastructure capacity. It would use a radically different character, scale, and impact than anything that we've seen so far. And if we put the regulations in and we say, here are the regulations, fine. We can go down that road, but there's nothing to do it. They're trying to go around the process. In Graham versus the City of Frankfurt, again, a Kentucky law or Kentucky case, courts have overturned CUPs where the approving body failed to connect the proposed use to any element of the comprehensive plan. Guys, in your packet on all your cases, you have to say, here's the evidence, here's my motion, and it is consistent with the comprehensive plan. So how do you do that if it's not in the comprehensive plan? Let's go back to the beginning. Still have 5 minutes. Need the overhead. Listed as data center, community, private utility.
Hang on, Rob, hang on. All right, go ahead.
Must be specifically named. And here's what the administrative official, in this case Ryan, must do. He must conform to the literal terms of the zoning regulation. A CUP is a special area. It's not about putting your garage a foot closer to the property line. This is not about putting it a garage a foot closer to the property line. This is about misusing the regulations and going around. And Kentucky law and cases have been very clear about this case. These terms matter. Literal, specifically. You can't ignore that. Thank you.
Okay. Okay. Questions for Rob? Any questions? Questions
I
down
have
here?
a question.
Yeah, go ahead, Charles.
Yes, sir.
So what you were saying, in essence, is at this point in time, there is no law for this specific facility?
Yes, what I'm saying is that a CUP, as defined under the KRSs, which are the law of Kentucky, there's nothing in there that says anything, a private utility. So LG&E is regulated by the Public Service Commission. They're there for our service so that you can turn on your lights and I can turn on mine and they can turn on theirs. But what happens if there's no data center here? I still get up in the morning, I still turn on my phone, and yes, my phone uses certain infrastructure, but I promise you, this data center is neither essential. Now, we can decide whether it's desirable in an industrial zone. We can decide that once we get the regulations in place. But yes, sir, you're right. It is silent. There is nothing there. You are correct.
Just for me.
Yes.
So you're saying there is no law for such a center here?
I am saying that. Yes, sir.
That's all I need.
Thank you, sir.
Okay. Any other questions?
Yeah, I have a question. Do you have any comments about the timeliness of your appeal?
Yeah, because what was presented in the timeliness factor was when they went to TRC. So there is no thing. What we're talking about is when the CUP was filed. We're also, if you want to really get technical, I can tell you that when the CUP was filed, the money didn't go through. Find out when they paid for their application. I guarantee you, I'm within my 30 days. So the reality is, if I give you an application and you're down in planning and zoning, but there's no check that comes with it, you can't accept it. You can't take it. When I put in my appeal, guess what I did? I wrote a check. Rob Houchins, put my name on it for $400+ just so I could come here and protect Oldham County. So the reality is, it is absolutely timely because they didn't do it when the CRC has nothing to do with it. We're talking about the CUP, and we're talking about administrative. And the reason this applies today is also because we're not just talking about 53, we're talking about an administrative decision that's been done once and twice, and I promise you, it'll happen again between now and when the moratorium's been put in place.
Okay, further questions?
Did you imply that the recommendation the recommendation for private utility classification originally came from?
Can you put the,
Yeah.
I'm sorry.
Did the recommendation for the private, is something that it's,
Just put it a little closer to your mouth.
yeah.
I know, it works that way. I've been sitting there.
So, did you indicate that Mr. Fisher's decision to use a private utility was on the recommendation of Western Hospitality?
Yes, I can show you that letter.
Okay,
Would you like me to show you?
sure. Would you put it back up?
Take me a second. I mixed up my papers now. Of course, it'll be the last one. Can't put it all on the screen, but here it is. It's from Dinsmore. You can see up in the right-hand corner, it's Cliff Ashburner. And you can see that he's writing on behalf of his client, Western Hospitality. In the second sentence, it says, the proposal is for construction of a data center with 8 buildings. And the comprehensive zoning ordinance, the use is best defined as a private utility.
Okay. And I believe that Mr. Fisher, during his testimony, indicated there were discussions or meetings prior to that, but I'm hoping he'll address that in his rebuttal.
I will refrain from telling you what Mr. Fisher knows or doesn't know.
Absolutely. It wasn't, it was just a
Yes.
pausing for later.
Yes.
Thank you.
Thank you, Mr. Gray.
Okay, further questions?
That it?
No more questions? Thank you, Rob.
Thank you, Mr. Chairman.
Okay, if we could have Appellate Lampton come forward, please.
Good morning, Mr. Chair and Board. My name is Randy Strobo. My address is 730 West Main Street, Louisville, Kentucky, 40202. I represent Nana Lampton, and I'd like that time to stop for 1 second because I still have a point of clarification because I'm a little confused by what you all talked about with cross-examination. You're allowing us more time during rebuttal to cross-examine?
That's what's been proposed.
Okay. But can we have some clarification on that before I start? Because that'll dictate how I do this presentation within these 20 minutes.
We'll make that proposal during the rebuttal time.
So I'm requesting again then that I'm allowed additional time now for cross-examination?
Yep.
I need some clarification. You're making it very hard on your attorneys to figure out what's going on.
That has been proposed to do at rebuttal time.
Is that going to be, can we make a decision now whether or not that's going to be granted?
Point of order, that's relevant to me as well.
The board can make that decision now if it wants to go ahead and decide that it will extend the rebuttal time to allow for cross-examination by however much time it wishes. I think that probably would be good for the parties to be able to plan for purposes of presenting their case. So if the board wants to entertain that, I think that it's at liberty to do so now.
Okay.
Thank you, Mr.
Board,
Chair.
you've heard what's being requested.
Yeah, I'll make a motion to extend the rebuttal time periods for each party to 15 minutes total.
A total of 15.
Yeah, total for 15, like for each party.
Okay. All right, we've got a motion. Do we have a second?
I second.
Thank you, Charles. Discussion? All in favor signify by saying aye. Aye. Those opposed? 15 minutes for each party.
Thank you, Mr. Chair and Board. That's very helpful to know that. One more point of clarification. I would like to ask a couple questions right now. May I be allowed to do that? Cross-examine?
We just said at time of rebuttal, we were extending the,
Right.
what do we do?
I'm just asking if I can do that now.
I think how they present their case is up to them. I will say that we just contemplated that the cross-examination would happen during rebuttal, and that was why the time was extended. So I think that's at the discretion of the board how it wants to handle that, but I do think we were just represented to that cross-examination would happen in rebuttal, and that was why we extended the time for everybody for 15 minutes in rebuttal.
I would just say that's a pretty inefficient way to do cross-examination because what I say after cross-examination kind of dictates my presentation. So I would just like to ask one question of Anna and move on.
So do we want to allow cross-examination during the allotted 20 minutes of the current presentation? They have 20 minutes. We've extended rebuttal to 15, but we haven't extended the presentation. So he can use presentation however.
I think that's acceptable if that's what the board wishes to do.
Okay. Board members, do you all have any problems with that?
I make a motion.
He's allotted 20 minutes, however he wishes to use it.
I make a motion that we extend the time 5 minutes so that they can do this.
I would recommend against that because we would have to go back to the other appellate and planning director and extend their time as well. I'm saying he's allotted 20 minutes. If he wants to do cross-examination during the allotted time, so be it.
I'd agree.
Is that acceptable to everybody?
I'd agree.
Okay, very good. You have 20 minutes, and we can start the clock now.
Thank you, Mr. Chair. Anna, if you don't mind, real quick. Thank you. Good to see you. You testified that the Planning Commission staff gave, or the planning staff gave notice on March 31st of this year, correct?
Notice of what?
You published an application on March 31st.
Yes.
Do you consider that giving notice?
Yes.
Are you familiar with KRS 100-261, procedure for all appeals to board?
No.
I'm going to read you a sentence.
Can you repeat that? Sorry, I thought you said 261. This is 100.261.
I'm sorry if I misspoke. Yeah, 100.261. Okay.
Can I correct my answer? Yes, I am aware of that.
Sure. Thank you. The second sentence says, such appeal shall be taken within 30 days after the appellant or his agent receives notice, correct?
Correct.
That doesn't say give notice, correct?
Correct. Was your appellant, is your client an adjoining property owner?
Does it say an adjoining property owner is required to appeal this?
No.
Thank you. No questions. So that emphasizes the fact that my client, and she's here today, received notice in early May about whatever determination was made. And the requirement is that she receives notice, not that the planning staff gives notice. Now, onto the mootness argument. I'm going to talk about mootness, I'm going to talk about timeliness, and then we're going to get into a couple expert witnesses to testify about private utilities in Oldham County. For mootness, there's three main points. First, it's unclear when a determination was made here. We didn't hear testimony from Ryan earlier. If I had more time during this period, I would have asked him, when did you make that determination? He hasn't said that in his testimony here. He hasn't made a statement to the timing of that in his comments that he filed previous to this hearing. If the determination was made prior to the application being filed, the withdrawal of that application may be irrelevant because that determination was not based on any specific application. All right? So if he makes this determination before the application was filed, and it wasn't specific to that application, then it's clearly not moot. It's also unclear, like I said before, when the determination, what the determination was based on. If the determination was made that generally a data center is a private utility facility in Oldham County under your zoning ordinance, that could apply to many different applications going forward. And third, if the determination was specific to the withdrawn application, there is nothing stopping the applicant from filing that same application for the same property again in the future. If they do so, and the applicant or the planning staff uses the same determination, we will have passed the deadline to appeal that determination. And this is a legal phrase, that's generally not acceptable as capable of repetition yet evading review. So at any time, this applicant can refile based on that determination. And regardless of those three reasons, we're all here now, and we should have the right to proffer evidence as an efficient use of this board's time. We have the right to be heard today. It's contained in the statute, and we have a due process right to be heard. On the time of this argument, my client is here. She can testify if you want her to that she's never received any notice of any official determination. Mr. Brown talked about strict compliance with the planning and zoning regulations and statutes. Again, it's not when the appellant, it's not when notice is given by the planning staff, it's when my client or the appellant receives the notice, and it's clearly here in KRS 100-261. An application itself, so an application for a TRC hearing or an application for a CUP is not notice of an official determination. Where in that application or in the supporting materials is there an official determination? It's not there. There's no documented official determination. We asked Ryan for the documented official determination. He said he doesn't have any. There's also no reference to an official determination in those documents. So even the applicant's staff or the applicant's attorney did not point to any official determination in those applications. We only filed this appeal based on an email that was discovered through an open records request in early May that said that it was deemed, it was an email, I think Ryan showed it, that they had deemed a data center use a private utility facility. That's all we had to work with. Again, that is not an official determination, and that is not notice of an official determination. And in Mr. Fisher's comments submitted by his attorney, he still, as I said before, does not state when a determination occurred or if an official determination ever occurred. Still, we filed within 30 days of that discovery, of that email, and therefore this appeal is timely. I have about 14 more minutes. I'm going to talk briefly about the merits of the determination, if there was an official determination, and then I'm going to turn it over to two expert witnesses. One of them is Greg Dale, an expert planner out of Cincinnati who does a lot of work in Kentucky, and then Tom Fitzgerald, who will talk about the definition of utilities in Kentucky. Well, one, I would like to adopt everything that Mr. Houchins has just said regarding his presentation. He did it very eloquently, and I should probably just go ahead and offer him a job today. But everything that he said today, we adopt and incorporate into our comments. As Mr. Fisher stated in his email, Oldham County does not have anything as far as permitted or conditional uses for data centers. Kentucky law, primarily KRS 100-237, requires conditional uses to be specifically named in the zoning regulations. You've heard that already. It's not specifically named. I think everybody agrees that data centers are nowhere found in your zoning ordinance or your comprehensive plan. And that is the reason why Ryan is doing all the hard and difficult work to pass new regulations right now with the community. Obviously, they're not passing new regulations that say data centers are private utility facilities. It's much more regulated, and although it's not final yet, I suspect it's not going to be equivalent to a private utility facility. A data center is not a private utility. Mr. Fitzgerald will talk a little bit more about that, more specifically about historically and traditionally what a utility is and what should be considered in that definition of utility. And another point I'll make quickly is that the Oldham County, your fiscal court, your planning commission has had private utility facilities reserved in your zoning ordinance for years. There's a section in your zoning ordinance that says private utility facilities, and it says reserved. Ever since I've been practicing in Oldham County, I've seen that be reserved. Obviously, if it's reserved, you haven't regulated for it, and it's not specifically regulated in your county. Now, I would like to bring up Mr. Greg Dale to testify. I'm going to kind of do a little bit of an intro for him. Okay?
Yeah.
So, Mr. Dale, state your name for the record.
C. Gregory Dale, D-A-L-E.
And are you an attorney?
No, sir.
We need to get you sworn in.
Go ahead and do both of them at the same time. 'cause
Okay, that's fine. If we want to do both at the same time, are you also? All right, pause the time.
Really? Okay.
Okay, we'll get you both sworn in at the same time.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Is Greg Dale, is that correct? Thank you, Greg. And Greg, we'll start the clock. We'll give you 3 or 4 seconds until your statement here.
Okay.
So go ahead and start at 3 or 4 seconds.
Ready? Yeah. Ready? Okay. Where are you employed?
I'm a principal with the planning and zoning consulting firm of McBride Dale Clarion.
And what does that entail at your firm?
We are professional community planners. I'm certified by the American Institute of Certified Planners. My work has been working for both public and private sector clients on planning and zoning issues, really throughout the country with a particular focus on Ohio, Kentucky, and Indiana.
And how long have you been there?
We've had the company for about 25 years.
And do you have experience working in Kentucky?
Yes.
What kind of experience? What kind of experience?
Over the years, it's been varied. We've worked on comprehensive plans and related zoning issues in Nelson County, in Frankfort, Franklin County, and Scott County, throughout northern Kentucky and Elizabethtown over the years.
And were you asked to give an opinion from a planner's perspective on whether a data center uses a private utility facility or building under Oldham County zoning ordinance?
Greg, and if you can speak more into the mic, thank you.
Yes.
And what is that opinion and why?
It is that, and you have a written report that I'll submit here. My opinion is that data centers are not permitted uses anywhere in Oldham County and don't fit within the term private utility. And there are some other related opinions, but those are the ones that I'll focus on this morning here. No, I've got it. Yep.
We'd like to submit this report into the record.
Ready? Mr. Chairman, I find myself in a bit of an unusual situation here in that I went through the work to develop that report. I never met Mr. Houchin until this morning when he sat down in front of me. And as he presented his information, I'm thinking that was pretty much what I was going to say. And I wanted to be clear that I had not seen any of his interpretation, and I'm not local. I come at this purely from the perspective of somebody who's looking at your zoning code and trying to interpret your zoning code, and that's all. So I think I can keep this a little bit shorter than I had intended. I think we all agree. It's clear now that data centers are not listed anywhere in your zoning ordinance. We know that. I think we can agree that your administrative staff has worked very hard to do their due diligence to try to, and you've heard different phrases and you see different things in the record, to try to find the closest use in the zoning code that fits what's being proposed. And so please don't take what I'm saying as criticism of the staff. I appreciate that hard work and I appreciate the effort to try to be cooperative. But there's a fundamental difference, in my opinion, in terms of how you approach this. As Mr. Houchin pointed out, your zoning code has some very specific language in it. He talked about the literal terms, that it be interpreted in accordance with the literal terms. There's another provision that I don't think he mentioned that's in this, near the same section, section 010-050. And it talks about uses, and it says, unless a use is expressly permitted, it cannot be initiated in the county. Now, expressly permitted means explicitly or specifically permitted. So your zoning ordinance has a pretty narrow path, which you apply the language literally, meaning very specifically as written. And if a use is not expressly permitted, it's not permitted, right? So while, again, I appreciate the diligence that the staff has applied, that fundamental approach of saying whenever we have these new uses come in, we have to find some place in the zoning code to hang them on is just not what your zoning ordinance requires, and it's not what zoning ordinances typically require. The basic rules of construction and zoning from a planner's perspective are that if a use is not identified as being permitted, it's prohibited. And history is full of times when you have new uses come in. You heard about event centers and barns. Cell towers were a big thing a while back. No one knew what to do with cell towers. And you went through the hard work. You now have a full chapter on cell towers that address the particular concerns of that. So while this effort to find the closest use may reflect a good faith effort to try to be cooperative, that's not what your zoning code says. Explicitly permitted and literally applied. Now, there's some more details in my report, but in the interest of time, I'll stop with that.
Next up is Mr. Tom Fitzgerald. So, Mr. Fitzgerald, do you mind stating your name for the record as well?
Sure. Tom Fitzgerald, 1600 Dundee Way, Louisville, Kentucky.
And where are you employed?
I am employed by the Kentucky Resources Council as a contract attorney doing legal aid on environmental issues and utility issues. I also moonlight as an adjunct professor at the Brandeis School of Law teaching energy law.
Are you here in your capacity in that employment?
Yes, I was asked to provide an opinion on whether the data center falls within private utility under the Oldham County ordinance.
And what was your position prior to that at KRC?
For 37 years, I directed the Kentucky Resources Council.
And did your work include the regulation of utilities in Kentucky, and how so?
It did. We represented a number of organizations, nonprofits, dealing with affordable housing and low-income energy assistance in front of the Public Service Commission for about 30 years.
And did your work also include the drafting, interpretation, and review of statutes and ordinances across the state?
Yes, it has.
And you mentioned you're also an adjunct professor of energy and utility law at U of L. How long have you been doing that?
1986 is when I began, so I've been teaching energy law, and environmental practice on a rotating basis since then.
And are you still licensed to practice law in Kentucky?
I am.
And were you asked to review materials in this case?
Yes, I reviewed the application that was made for the Highway 53 data center, as well as the justification letter that was provided on June 12th on behalf of Planning Director Fisher, and then reviewed the statutes and regulations that are involved in data centers, as well as planning and zoning.
Did you review all the appeal materials as well?
I did.
And have you been paid for giving this opinion?
No.
And what is your opinion and why?
My opinion is that that a data center is not a private utility under the Oldham County planning or Oldham County zoning ordinance, and that is so for four separate reasons. First, and after I think a fairly diligent search, there is not a state in the nation that treats data centers as public utilities or as utilities. They do place a tremendous demand on electric utilities because of their energy use, and a number of states are trying to address that and protect other ratepayers from having to subsidize the new energy demands of data centers. But data centers are not considered to be nationally or in Kentucky a public utility. I confirmed that by talking to the General Counsel with the Public Service Commission and asked, do you regulate data centers as utilities? And the indication was no, we don't. Because first, they are not providing a service to the public, and that's a term of art that's used. I think in the Oldham County ordinance, it's providing for the public a service. What you're dealing with there is whether you're providing to the public on a non-discriminatory basis, typically under rate regulation and typically with a geographic monopoly. You're providing an essential service: gas, water, electric, wastewater, telecommunications. And this is not considered to be, at a state level, a utility because it is neither providing a service directly to the public, nor is it engaged in telecommunications. It is providing data, it is crunching data, but is not providing messages in the classic telecommunications sense. The key here for why this would not be considered a private utility is because it is not in public service. It is not serving the public by and large. There are several different types of data centers. This one, from what skeletal information was provided in the application, appears to be what's called a co-location or a powered shell, where you have a real estate developer that will develop the property, make it suitable for a data center by creating the zoning and the planning, meeting all of the obligations for planning and zoning, and then providing the interconnection for electric service, but does not provide the actual data services. They then flip the site to either a hyperscaler like a Meta or a Amazon or a Google, or to an enterprise data center that provides rental services for a number of different companies that want their data processed. So that's the key, that it's not in public service. It also, when you look at the structure of the Oldham County Ordinance, as Appellant Houchins very aptly pointed out, the private utilities are under community services. There's a list of different types of conditional uses, and there's no indication that this data center would be providing a service to the public as opposed to a discrete company that then sells their services to subscribers. I'd be happy to answer any questions that you might have.
Okay, is that it?
Just a few concluding remarks with the rest of my time. So we argued, and I think successfully, that this is not moot. This determination can be applied again. It's capable of repetition. There's nothing stopping the applicant or the developer from filing that application again for the same property under the same conditions. Our appeal is timely. The statute requires that my client receive notice. She received notice in early May, and it's still unclear when any official determination actually occurred. You heard testimony from Mr. Dale, Mr. Houchins, myself, and Mr. Fitzgerald about how there are no specific, nothing is specifically named in the zoning ordinance or the comp plan, and also that this is not a private utility under any common definition of the term. Thank you.
Okay, any questions for this appellate?
I have a question. So the question of notice given versus notice received. So, I mean, is there case law or is there precedent in terms of, like, if a letter in the mail takes 2 months to get delivered, does that mean it hasn't been received and so you haven't received notice? Or what is reasonable, or what does the law interpret the words given versus received?
There's not much case law on it. Mr. Grady actually participated in one of the cases where this was discussed a bit, but the court didn't say much other than, I guess, given it, well, when the appellant said it was given notice, that's what the court believed. Or when it received notice, that's what the court believed, and that's where they went. They didn't really go into the details of it, but the statute is pretty clear. It's when my client, the appellant, receives notice. And I think it's still unclear when any official determination actually took place. We don't know when that took place. All we know is when we think we found out about it, which is that email we mentioned, and it's in my appeal letter, that talks about that the data center use was deemed a private utility facility. But that email itself is not an official determination, so it's still unclear where it is. We just filed it out of abundance of caution, because if we don't file this lawsuit or file this appeal, we waive the right to challenge the definition interpretation by planning staff. And I guarantee you, if we didn't file this appeal and we went to the conditional use hearing in July and August, whenever it happens, they will say you can't challenge this now because you waived it, because the official determination was already made and you missed the deadline to challenge it. So that's why we're here today. We don't want to waste everybody's time. I mean, we're here because we have an obligation to our client to exhaust our administrative remedies. And the way to do that is to file this appeal. That's the way the law works, unfortunately. If we didn't have to be here, we wouldn't be here. And I'm sure the hundreds of people here wouldn't want to be here listening to these legal arguments, but that's what we're stuck with, and that's why we're
So
here.
again, I'm struggling. So in terms of notice, is something that's published in the Oldham Era or published on the website of planning, and does that not, do they need to send a letter out to every resident in Oldham County and make sure they received it, to make sure it's received?
I think it's very fact specific, and it's when my client received notice. And whether it's through email, whether it's through a telephone call, whether it's her talking to a friend or talking to an official, again, I don't believe that we've received official notice yet. But out of abundance of caution, we filed this appeal just to CYA, as people say.
Okay, thank you.
Yep. Any other questions?
Okay, further questions? Okay, thank you.
Thank you.
Okay, if we could have Appellate Oberg and Oberg, we are Oldham County, come forward, please. Okay.
Good morning. Am I coming through clearly? Can you hear me?
Yes.
My name is Hank Grady. I'm an attorney from Versailles, Kentucky. My office is 137 North Main Street, Versailles, and I live in Midway, Kentucky. And I'm here on behalf of Nathan Oberg, David Oberg, and we are Oldham County LLC. The good news, if I can give you good news, is that my appeal is essentially verbatim from the appeal that Mr. Strobo wrote for Ms. Lampton. And my argument today will, I don't think, take 20 minutes because I want to incorporate what Mr. Strobo said and his witnesses because they are, that is the evidence I wanted to present as well. And now that I've heard Mr. Houchins, I want to incorporate his presentation to you as well. There are 3 points that I want to emphasize, and they've come through sort of, but I want to try to emphasize them again for you and try to make this point as clearly as possible. Mr. Farco, you asked questions about, do we have to mail notice to everybody? And the question of public notice. I want to ask the Board of Adjustments to distinguish between notice of a zoning application and a decision by a zoning administrator. Notice of an application is one thing. That doesn't tell you anything about the decision of the zoning administrator. Notice of the application doesn't start the 30-day challenge rule under 100-261. And in this case, the first application was for an application to go to the TRC, which is irrelevant as far as why we're here today. The application that mattered was the application for a conditional use permit. And as Mr. Houchin said, that application only became final when the fee was paid. And then someone had to make a determination that this application was able to go forward because they defined a data center as a private utility. That's the decision that is under attack here, under a KRS 100-261 challenge within 30 days of receiving notice. The previous statute, 100-257, also provides for an appeal to the Board of Adjustments of a decision of the zoning administrator. And in that case, it says in the opening sentence, when the applicant is unhappy with the decision of the zoning administrator, he must appeal to the Board of Adjustments. The statute on its face doesn't apply to protesters. It applies to somebody who has applied to the zoning administrator for an interpretation. So in this case, hypothetically, if Mr. Ashburner had applied to be considered as a private utility, and the zoning administrator had said, you don't belong there. He, as the applicant, could have appealed that denial to you. That's why the issue of when do you get notice matters, because this has to do with something that happens generally in-house. As both previous appellants have noted, we still don't know when that determination was made. We know in Mr. Brown's filing on behalf of Mr. Fisher that it was never made in writing. It was a verbal determination. That's in footnote number 2. But in this case, what we know is, as of May 1st, we saw a completed application for a conditional use permit that was going to go forward, going to be held based upon data center, which is not listed anywhere, as we have discussed. And it was being best fit into a private utility, which in my opinion is not a good fit at all, and I think the previous 2 experts have helped establish that. But that's why the May 1st date, when we were looking at a completed CUP application and a determination that it could go forward, it wasn't misfiled in the opinion of the zoning administrator. It was that decision that was in error, we believe, and that's what we have appealed to this board. We filed that appeal on May 19th, so it was timely from getting notice. My client got notice the same time as Lampton did. So the notice on May 1st, which is cited in our petition, was appealed on May 19th. Now, I anticipate that we will be appealing again for a new address. But that doesn't change the fact that this appeal is before you. It was timely filed, and it is a error that is capable of repetition yet avoiding review, so it avoids being dismissed under mootness. We would ask you to reject both of those defenses and consider it on the merits. Now, I want to discuss a part of the merits argument that Mr. Houchins did not mention. Mr. Strobel mentioned it briefly, but I want to mention it a little bit more directly. There is, as I read the zoning ordinance in this community, currently no authorization for a conditional use for a private utility anywhere in the county. It is defined in the definitions. But under conditional uses, private utility has no narrative. It has never been spelled out by your fiscal court and your city councils. It says reserved, which means it is a concept that is under consideration for a kind of conditional use someday when the legislative body decides what are we going to allow as a conditional use under the term private utility, but that hasn't happened yet. There is no text for the conditional use of a private utility. So trying to hitch a data center onto a private utility fails both places. So reject this not only for the reasons that it's not a private utility, but this county has not even authorized any conditional uses for private utilities. The legislative bodies must, when they think it's time to approve private utilities, spell out where they can go. Right now they're allowed everywhere in theory, but they must spell out what are the limitations. How big can they be? If they're in a residential zone, what's the difference there versus an industrial zone? Somebody has to address that, and it's not you. It's not the planning commission. It is the fiscal court and the city councils. The legislative bodies must get rid of the word reserved and spell out what a private utility is and is not, and how big they can be, how loud they can be, how noisy they can be. That hadn't happened. So the private utility is not the best fit That's not the right test. We're not looking for a best fit. We're looking for literally, where are the words data center? They're not there. We're looking for a specific use. It's not there. And saying it's best because the applicant wants to try to squeeze it in before the legislative process has run its course is a effort by the applicant that you are asked to reject. This applicant is clearly trying to beat the clock. He is trying to come in ahead of a moratorium and legislation that describes how this county is going to handle data centers. And you should not be helping him beat the clock by sneaking this in as an illegal use that is untimely. I don't have to cite the statute. Previous speakers have cited the statute that I think controls 100-278, 100-261. That's where the words literal and specifically enumerated are mentioned. And so I don't need to take up your time and my time and the audience's time repeating. But I do want to emphasize the argument that has not been emphasized, and that is in this community, a private utility in your ordinance is reserved and has not been authorized. And with that, I will adopt the comments of the previous speakers and ask you to grant our appeal and set aside the finding of the zoning administrator and require this applicant, if he wishes to pursue a data center in this community, to wait until the community has data centers in the zoning ordinance and ground rules for this community to proceed under and for this applicant to proceed under. Please grant the application and require him to go through the process like everybody else properly does in the planning and zoning context. Thank you very much.
Okay. Are there any questions for Oberg and Oberg? We are Oldham County. Okay, very good. We're at a point now where it's testimony for those speaking in favor of the appellates. Like we said, collectively, there's 10 minutes for this. Board, do we want to take a quick recess before we get into this, or are we good to keep going?
Sounds good.
You want a break?
Please.
10 minutes?
You want to take Alamo? Yeah.
Okay, can I get a motion for a 10-minute recess?
Motion for a 10-minute recess.
Do I have a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed? 10-minute recess. Please turn off your mics. Ready, please? Okay, I need a motion to come back into session.
Motion to come back into session.
Do I have a second?
Second.
Thank you, Mark. Discussion? All in favor signify by saying aye. Aye. Those opposed? We're back in session. Okay, this is the time where those speaking in favor for the appeals will have 10 minutes collectively. I encourage people to just be ready to come forward. And what we're going to do is all of those that wish to speak in favor, let's go ahead and collectively get everybody sworn in. So if you want to stand up. Okay, let's collectively get you sworn in.
Everybody raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank
Okay,
you.
when you come to the lectern, just come up. You have to speak into the mic. Things are being recorded, sound and audio, or video and audio. State your name and address, and then tell us why you're in favor of the application or the appellates. Barry, we're going to start with you, and I guess ma'am against the wall. What we're going to do is just go straight across this way and kind of zigzag our way back, okay? So ma'am, you'll be next, and then just be ready to come forward when you're ready to speak. 10 minutes collectively. All right, Barry, if you want to state your name and address, please.
Barry Laws, 3411 Fenley Mill Road. I'd like to appeal to the board for more time for us because we have a lot of people wanting to speak from our community.
What we're going to do is exhaust the 10 minutes, and then we'll make a motion for extending the time.
Very good. I'm going to be very quick. In the zoning, comprehensive zoning ordinance, it says private utility buildings and facilities, any system, facility, building that is operated by. I'm going to stop right there. Who is operating this? If it's not apparent who is operating this, it's not in our definitions. Thank you.
Okay. Yes, ma'am.
Jamie Hilligans, 7925 Oregon Creek Road, Pendleton. Data centers are not necessary for public health, safety, and welfare. On the contrary, there are potentially negative consequences. Data centers, depending on the size and design, could require millions of gallons of diesel fuel storage on site, could use millions of gallons of water per day, could generate polluted wastewater, could power heavy polluting diesel generators during power outages, and will impact the ambient temperature and humidity levels of the local ambient environment. Let's take the power away from these out-of-state corporations and give it back to the people of Oldham County. Thank you.
Jennifer Toll, 3905 Hambletonian. I'm speaking on the fact that, again, it's not a utility. Data centers themselves are arguing against being regulated as a utility. If you don't want to be regulated as a utility, you don't get the privileges of a utility. Coy Stone, Director of Data Center Services at Bluestone Energy, says, data centers provide the service of a highly conditioned and very reliable power source. Customers can't get that by plugging their service into the utility power plug in the wall. Comparing a data center to utility is similar to saying a car manufacturer is a provider of sheet metal. The automobile has metal as a component, but there's much more to it. The data center provider is playing the same role. Calling a data center a utility opens us up to anything wanting to come in here and call itself a private utility based on the reasoning that was given.
Okay.
My name is Olivia Tipton, 3601 Alexander Drive.
I'm sorry, I didn't catch the name.
Olivia Tipton. Okay. So I have 2 points, one of which is this really all relates to the notice that has gone down. The date that is being used is a TRC notice that was sent out, while simultaneously we're saying the TRC is a choice or not required. I could argue that at another point, but if we're going to say it's not required, why are we using that date for trying to throw out these appeals? The other thing in reference to how is notice being counted, KRS 100.237 Section 6 specifically says that they have to mail out notice to adjoining property owners via certified mail. I am a adjoining property owner and I did not receive a notice of this via certified mail. Thank you.
Okay.
Hello, my name is Kathy Harakovic. My address is 1002 Cherry Ridge Run here in LaGrange. I would ask that everyone here, when they approach this mic, be required to give their address and where they're from, as well as we are. I'm a single mom. For me to give out my address is not on my priority list. I've been a single mom for 20 years. I've raised my children here in Oldham County. My children came to me last weekend and said, "Mom, get out. Sell your house while you can." 4 houses have gone up for sale in the last 2 weeks in my neighborhood, which is Cherrywood. We can hear the interstate from Cherrywood. I have no idea what we'll be able to hear from Sauerbeck in Cherrywood. Applications for purchase are being withdrawn until this data center is completely decided. All we are asking is that you all do your due diligence. Let the appeal go through. Let them follow the rules. We all do. We want it to be for our kids. My kids have already told me, 28, 25, and 22, we will not be back if this data center goes through. Let that sink in. My children, I want them to be here with me. I want them to raise their children here in the community that I raised my children. Is this personal? Yes. Is it emotional? Yes. Is it passionate? Yes. We wouldn't come to you if it wasn't. So all we're asking is that you grant the appeal and you go forward from here. Thank you.
Okay. Who's next? Who's next? We had several others.
Good morning. My name is Robin Vessels. I live at 1320 Bluegrass Parkway in LaGrange. And what I wanted to do was to address the definition of public utility as it is in the zoning ordinance. Any system, facility, or building that is operated by other than a municipality, governmental agency, or public utility providing to the public a service deemed necessary for the public health, safety, and welfare. The definition of public health, safety, and welfare and public administration is it refers to the well-being of the community, encompassing physical and mental health, freedom from danger, and overall thriving. Public health focuses on disease prevention and health promotion. Public welfare broadly encompasses the conditions that enable people to thrive, including social, economic, and environmental factors. What is stored on these servers and the data center is not all good. There is what is known as that's the deep dark web. I mean, you've got human trafficking occurring. You've got child pornography that is downloaded onto these servers and onto these websites. There is no way that anybody can argue that that is for the public health, well-being of the community. Thank you.
Okay, thank you.
Hello, Arthur Blake, 1813 Foxborough Road. A few flittering thoughts. I started listening to the meeting at first, and they hung their whole hat on a big hook that was all about timelines and deadlines, and basically trying to go with, I think all of that is can be debated, but really what the appeal is about, there's a letter of the law, there's an intent of the law. I'm not so much concerned about, who went to lunch at 12:15. What I'm concerned about are things like the letter of the law, like this is supposed to help safety, welfare. Where does it help? Just, I'm not being greedy here, but how am I safer? Okay, if this doesn't get built, just my phone quit working. Has it helped me? Is it help my welfare when my bills go up and I breathe all this gas? My health? Does it help with the pollution? Okay, that's health, safety, and welfare. I think that should all be, especially with the neighbors that live right close to, whether it's Auerbach or whoever's going to put a permit in here and take one out and put one back in. This needs to be written more concisely and described as zoning as part of regulations that people really need to. This isn't a game. Let's really give this a chance to do the research, do the documentation. These appeals are valid in my mind. I hope you end up feeling the same way after looking at all the different angles here. But just the long and the short of it is need to get our ducks together and do the right thing.
My name is Mary Lowry, 326 Maple Avenue, Pee Wee Valley. I'm here to support the appellates, and I believe that there are a lot of people behind me that have not spoken that are also here to support the appellates. And we love our county, we want what's best for our county, and we want you to listen to us. Thank you.
All right, show of hands. Who else? We're out of time. Who else was intending on speaking? 1, 2, 3. Have you all been sworn in yet? Okay. Board, do we want to extend the time to allow the other 3 members?
Motion to extend 5 more minutes.
5 minutes? We got a second? Is 5 minutes sufficient, I ask? We good? All right, we got a second. Any discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed? Christie.
First of all, I would like to thank you and our
5 more
county.
minutes. I'm sorry, your name?
I would like
address?
Liz Englert, 5400 Old Sligo Road, LaGrange, Kentucky.
Liz, hang on 1 second, please. There we go. Go ahead.
I'd like to thank the county for balancing the budget so well by having deputies here today to protect us from each other, and by having toilets that don't flush so that we don't waste water. We've lived in Oldham County for 30 years now, and we've enjoyed every minute of it. Our children live here. They've enjoyed it. And I'm afraid our children will feel very much like one of the first speaker's children. They do not want to live in an Oldham County that is an industrialized version of what we used to be. And I think there's more to life than money, if that's the excuse for this. There are people who came here for a quieter, more personal form of living. And those people are being betrayed, we feel, by our elected officials and their appointees. Thank you very much.
Liz.
I'm Garrett Eccles. I live at 4008 Oak Ridge Drive, Crestwood, Kentucky. I do not have any expertise on any of the things that have been discussed today. I've been a realtor for 21 years. Most of my business has been in Oldham County. I study the statistics carefully every month for 21 years. For the first time ever, in May of 25, we were down 58% on pending sales compared to May of 24. The same month, May of 25, our listings are up 86% over 24. We've never seen those kind of drops or those kind of increases. That's what drives property values. June is going to be worse. Thank you.
Okay.
My name is Fred Burr. My wife and I live at 12113 Ridgeview Drive in Goshen. As a former member of this board, I never in the wildest dreams thought I would be asking to approve a conditional use permit on a multi-billion-dollar project. Clearly, this should be decided by elected officials, not appointed officials. Elected officials are subject to public judgment and public input. It seems to me that this is basically a move to chase tax dollars and a few jobs at the expense of the character and quality of life in Oldham County. This is not how government by and for the people should operate. Thank you.
Okay. Okay. Stop the clock real quick, please. All right. We have a couple more minutes left. Is there anybody else that wishes to speak in favor of the appeals? Come on forward. All right.
Do I need to restate my name or am I good? Okay, I got nervous last time and ran away. I was going to point out that the Board of Adjustments has the authority to hire an attorney to represent you. And I want to point out that all of us feel like we've been put in a bad position. And I want to highlight that I think all of you have been put in a bad position because you guys are being asked to make a decision that far exceeds your authority and your scope. And again, this is putting the responsibility on you guys personally in a capacity that you guys are not equipped to handle, nor should you be. And I apologize for that for you guys too. So thank you.
Okay. Okay.
One more thing, just for the people that don't like to get up in public and talk, if you are in favor of this application, could you please stand up? Well, I mean, sorry, in favor, yes. Sorry. No, so thank you very much.
Okay. All right, board. Are there any questions by the board members to anybody that was speaking in favor? Any questions? Okay. We have a presentation by Western Hospitality, 20 minutes. And yes, Rob?
When I filed my appeal, I filed this at administrative appeal. I was arguing about the decision made. Now what we've done here is we've given now the director 20 minutes, and now we're giving the appellant 20 minutes as well. We've conflated a couple of things and we put them together. This is why in the before I sent this in and said, no, we need to keep these things separate. I object to the fact that are given 20 minutes and an additional 20 minutes now. These are two separate things, and we've conflated and put them together.
Okay. You want to speak to that?
Sure. Just to provide a brief remark on this, the appeal that was filed was an appeal of a determination, administrative determination by the planning director. However, it directly implicates the interest of Western Hospitality Partners. In an interest of fairness, this board has to give everybody who is interested, what we call an interested party, an opportunity to be heard. That's why I recommended that Western Hospitality Partners be permitted the 20 minutes to be heard so that they can have their interest protected. Mr. Houchin's objection can be noted for the record, but the board does not need to take action on it.
Okay, thank you. Okay, if we could have Western Hospitality come forward, please. Okay, ready to start the clock. All right, Cliff. Oops.
There we go.
Jay, if you could, all right, are you using the overhead?
Yeah, if that's okay.
Yeah, Jay, can you get the overhead on our screens, please?
Oh, no, I'm sorry. I'm using the computer to start with.
Oh, I'm sorry.
I'll get to the overhead in just a moment.
Jay, if you can get the computer.
Cliff, before you start, do you want to put it in presentation mode, just so if you have any notes in there, they're your notes?
All right, we got you.
Okay. I'm not going to take the full 20 minutes. My name is Cliff Ashburner. I'm with Dinsmore and Scholl. My address is 101 South Fifth Street, Suite 2500, Louisville 40202. Here today on behalf of Western Hospitality Partners. Our position very clearly is in support of the interpretation that was previously made by Ryan to accept the application. I'll put into the record, as I have in writing already, that I think all three appeals are not timely. I think all three appeals are moot as they apply to one application that has since been withdrawn. I think those two bases alone are sufficient for you to deny the appeals, but I will go into more detail on those, and then I'll talk a little bit about your practices, your past practices, and the definition of private utility and kind of how that works. So first and foremost, the timeliness. All of the appeals were filed after April, the month of April, although the fact of the application was known community-wide in late March. There are more than 30 days between those two events. In addition, I do not find anywhere in your comprehensive zoning ordinance any specific notice that is provided to the general public beyond the publication of applications when applications are accepted. It is not a common practice in this jurisdiction or any other jurisdiction to send out a mailer, send out an email, send out anything that says we accepted an application. The common notice that is provided and what due process demands is that notice of a hearing is provided, in some cases by mail, in some cases by publication. Different jurisdictions handle it differently. Kentucky statutes demand that certain things are published in the paper. The acceptance of an application is not one of those. So what we're really talking about in at least two of the cases is actual notice. When did people actually know that the application was filed? And now I will use the overhead if I can.
Jay, if you can, are you doing the computer overhead?
I'm getting ready to use the overhead.
All right, Jay,
Okay.
if you can, thank you.
So I'm going to put on the screen initially, this is an article published in the Oldham Era. You can see the date on it is March 28th, although I'm not exactly sure if that date is accurate because it refers to conversations that happened on March 30th and 31st. In this article, both Appellant Houchins and Appellant Oberg were quoted. They were aware of the application at the time. I assume they were because they were speaking with a reporter from the Oldham Era about their opposition to the application. From a common perspective, this area is agricultural residential. That's a lot of what Oldham County is, said Houchins. That's Mr. Houchins, the appellant. And then there's a quotation there, having served on the Board of Adjustments. So I'm pretty sure we have the correct Houchins. He spoke about his service on the Board of Adjustment already. Further, in the same article, many members of the public have shared their opinions on social media about the application, with one group creating a Facebook page in opposition to the proposed data center. We are Oldham County. Page organizers, Nathan Oberg, the appellant, Tim Tipton, don't believe he's an appellant, and Rob Houchins spoke with the Era on March 31. They were aware of and in opposition to the application as of that date, meaning they were on the clock as of that date. And filing an application more than 30 days late, we got a lot of information from Mr. Houchins about specificity, literal terms. There's really nothing more literal than math. 30 is 30. If you file an application, you wait 30 days and nobody files an appeal, that appeal period, that appeal window has closed. In addition to, and in order to just clarify that we all kind of knew what we were talking about, you'll see here, this is a screenshot of the We Are Oldham County Facebook page. You can see that the physical address is the same physical address as Appellant Oberg, and We Are Oldham County as an entity, I guess, probably didn't exist at this time, but you can see that it is the same. And here is a post from April 5th. You recall earlier in the presentation, the Oberg We Are Oldham County appeal was filed May 19th. That one was not filed on May 1st. And it says they are trying to call this a private utility to get the ball rolling towards construction. This is not legal and sets a terrible precedent of where they can add future sites. So it's clear that the organizer, the person who composed this post, who I have no reason to believe is anybody other than Mr. Oberg, was aware of the interpretation, had actual notice as of at least April 5th, because he put in writing, this is a problem, you should oppose this. So I think with regard to the Houchins and Oberg appeals, there is sufficient evidence that they had actual notice of the fact of the application. They waited more than 30 days, and so their appeals should be dismissed as untimely. I'm not going to harp on the mootness argument, although you all have heard about that enough, I think. Both the Lambton and Oberg appeals specifically call out the application for March 19th. That application has been withdrawn. When you file an appeal, and typically, I'm filing appeals in the court system, you are appealing a specific ruling. You're not appealing a principle of law. That's a political act. A legal act is I am appealing a specific ruling. And I am appealing on behalf of a specific party. These appeals, by their own terms, were written about a specific application. That application has been withdrawn. Therefore, I think that you can dismiss, again, all of the appeals as being moot. So those are the procedural arguments. Now, if we can get back to using the computer. Thank you very much. So we obviously would like that the application be accepted. And I want to just kind of talk about sort of two roads that this can go down. One road is that the application is accepted, this application moves forward, maybe it is, or the application that's currently pending, which is not the application that was appealed from, an application, we'll just say it moves forward, and it comes to the board, and the board hears it on its merits. I heard a lot of comments from people earlier today with comments about the merits of the goodness or badness of a data center use. They don't like the power consumption, they don't like this or that about it. It wasn't really about whether it could be determined to be a private utility, it was more about I don't like the use, period. Those are typically arguments that are made when you're discussing the merits. And this board has seen uses like that in the past and made determinations because, as you all know, the standard that applies to conditional use permits is whether it's essential, and it's a very broad standard, I have to admit, whether it's essential and good for the community, essentially. So you all have the ability at that time to hear a lot of the arguments that you've heard already. The other road you go down is you sustain the appeal and you say, Ryan, you are not allowed to accept any application that is not clearly and absolutely defined to a T within our comprehensive zoning ordinance. And as was discussed before, the comprehensive zoning ordinance doesn't contain use categories like nail salon, large retailer, small retailer, gas station with diesel, without diesel. It contains categories of uses. It says restaurants. It doesn't say Indian food. It says restaurants. It says retail. It doesn't say 5,000 square foot retail or 100,000 square foot retail. It has categories, and people have to operate within those categories. And that is typically something that's left to the zoning administrator at first impression to decide, can I or can I not accept this application? So you can either go down the road that says, ultimately the board is going to make a decision on this case, or you can say, the board is now going to set itself up as an appellate court, and when a different business comes to town, Ryan, you may not accept it unless you determine it matches up exactly. And you'll either have to amend your zoning regulations for every new use that comes in, or you'll have to go through a proceeding like this. I will tell you what Oldham County's past practice has been, and it was referred to by Ryan in his initial comments about the event centers and about private clubs. There has been, in the past, discretion exercised to say, does this fit? And then we'll let the board decide if the application itself is meritorious and should be granted, or isn't and should be denied. So I would say keeping up with your current practice is the better way forward. So when it comes to private utilities, I don't know why that utility didn't show up there. Private utility buildings and facilities, I will echo Ryan's breakdown of the definition. It is any system, facility, or building that's operated by other than a municipality, government agency, or public utility. So I think there's no problem there. I don't think even among the many red-shirted folks behind me, they would argue that it's not a building or not a facility and that it's not a public utility. In fact, many people argue that it's not a public utility. Providing to the public a service deemed necessary for the public health, safety, and welfare. That's a question for the board to decide when the application comes before you on the merits. It's not a question for the board to take up now. It's a question for the board to decide when they hear more about what a data center does, how it undergirds a lot of the information economy, the information infrastructure that we all use. This proceeding is being broadcast on YouTube. It is preserved on YouTube. When somebody says it's in the cloud, it's in a building like the one that was proposed in the 53 application. I believe that this local regulation can be interpreted to say that that is a service deemed necessary for the public health, safety, and welfare. The distinction, that's okay. The distinction that's being made is either we're here to determine could Ryan have made that decision, or did Ryan make the right decision? And I think the role of the planning administrator is, can it be in this category? And then the merits of the actual application are left to this board. Now, a lot has been said about us wanting, WHP, wanting to try to skirt some process, wanting not to involve the public. Just a couple of reminders. Conditional use permits do not require public meetings, like community meetings. We had 2. Conditional use permits are not typically required to go to TRC. The 53 application did go to TRC before it was withdrawn. And the Sauerbeck application will go to TRC. And if these appeals are rejected, we'll come back to you for a discussion on the merits at that time. Now, when it comes to the interpretation of private utility and how it's been done in the past, I have one recent example that I want to bring to your attention. This is 1111 Dawkins Road. I handled this application. It was for a private utility. That determination was made. The application was brought to the board. The operator of 1111 Dawkins Road was a company that provides services to public utilities. They provide pipe and conduit, they install pipe and conduit for water companies, sewer companies, and telecommunications providers. A determination was made by the administrator at that time to accept the application as a private utility. Said, I think this could fit within the definition of a private utility. And we came before this board in late 2023 to provide you information about the proposed operation, how it related to utilities, and why it was meritorious and why it should be approved. And this board, when faced with an application that was to support a contractor that provides services to public utilities, said, yes, we will accept this, and yes, it is meritorious, and granted the conditional use permit. When you talk about what should be done, what shouldn't be done, oftentimes it's worth looking at what you are doing and how things are operating. Somebody mentioned a condition. I never thought that a conditional use permit would apply to a $6 billion project. I didn't either. I never thought that I would have a case that had that level of investment in my career. But here we are. And we have the regulations in place as they are, and we have the information that we have provided to you that we provided to Ryan. One last thing that I want to just point out is the practical impact of a successful appeal. So the practical impact is that the board will constantly be looking at the acceptance of applications. And they'll be doing it separately from looking at the merits of a case. And that is a situation that you do not typically find yourselves in. And I would argue that you should not put yourselves in. Applicants will not have the ability to have their cases heard on the merits. You've heard today from some of the appellants, we're not really sure that a final determination was made, but if one was, then we are appealing that we're not sure even exists. I think you can't have it both ways. I think either there's a final determination that's been made, and I believe the only official action that anybody's come up with is the acceptance of the application. The date of that was March 19th. The date it was published was March 31st. You've seen evidence of actual knowledge on the part of at least two of the appellants. I don't think any applicant will want to apply ever again if they think that there's a chance, well, I'm going to apply, and then maybe 30 days later somebody, or maybe 35 days later, or maybe 45 days later, somebody's going to appeal, and the board is going to let them appeal outside of the time and let them sustain appeals about withdrawn applications. I think that's a bad practice for this board or for any board. You have rules in place about appeals for a reason. The other practical impact is that something that is not specifically contemplated, at least to the level of detail that the appellants believe we should all tie things down, will require an applicant to come to the community and say, we need you to create a regulation. We need that regulation to apply to us, and then we need to go through a process to comply with that regulation. That is not something that I have seen in my entire career be a practice in any jurisdiction. In every jurisdiction in which I've practiced in Kentucky, it is commonplace for an administrator to say, I believe you meet this definition. I will accept an application on behalf using that definition, and we'll process it. And we'll take the merits of your case to whatever board it's assigned. As you all can see, this is a very public process, and I don't think that the accusation that we're trying to skirt any rules really has any merit.
Order.
So I would ask that you sustain the determination by Mr. Fisher. I think that on all three appeals, you have sufficient procedural grounds to deny them. as either being untimely or moot, and I think they fail on the merits as well. Thank you.
Okay. Questions by board members? Okay, thank you. Okay, we are at the time where testimony from anybody wishing to speak in opposition to the appeals. Same as before, collectively, you have 10 minutes. By show of hands, can I see those who wish to speak in opposition to the appeals? Okay, very good. Time for rebuttals. We already had a motion and extended the time for 15 minutes each. This allowed for time of cross-examination. We start 15 minutes with the planning director.
Mr. Chairman, Keith Brown here again.
Hang on, Keith. All right, go ahead.
Keith Brown here again on behalf of Planning Director Fisher. A lot of testimony has been given today, a lot of opinions, a lot of it on the general merits of data centers. I think it's important to boil this down to one real issue that's critical here today. Was Ryan Fisher's decision arbitrary, or was it not arbitrary? I don't think it was arbitrary. If it was not arbitrary, then the appeals should not be sustained and his opinion should stand. A board or a judge in circuit court does not evaluate how they would have decided some interpretation on their own, what they personally feel. They do what is called a review on arbitrariness. And there's case after case in Kentucky, starting with the American Beauty Homes appellate case, that addresses those issues. They look at substantial evidence. And certainly Mr. Fisher did a due diligence review of these issues. He looked at a number of provisions of the zoning ordinance. He looked at what other communities were doing. He tried to understand what a data center was and did understand it. And then he ultimately made his decision. He did his job. So what you are doing here today, in my opinion, is evaluating not what you individually think about this definition of a private utility being a data center, but did Mr. Fisher do his job in a non-arbitrary manner and make a decision that should be sustained? You just can't expect him to do anything more than do his best analysis and make a decision based upon the facts that were in front of him and the zoning ordinance and the comp plan that was in front of him. He has a certain discretion. That is why he has the ability to interpret matters. And as he said, these matters come up every week in various different applications. That's what an administrator does. He has to make various calls one way or the other, how he will look at something, how it will be handled. So he exercised that discretion. He did it on a rational basis and a non-arbitrary basis. You know, there's an old joke that if you put 3 lawyers in a room and ask them a question on an issue, you'll get 5 opinions or maybe more, okay? I think that applies to planners or engineers. And we have today certainly some gentlemen testified, Mr. Dale and Mr. Fitzgerald, who certainly have some credentials in their fields, but they just gave their opinions. That doesn't mean Mr. Ryan's opinion is wrong. It just means that they might have a different opinion than he does. Last time I checked, they don't work for the Oldham County Planning Office, okay? Mr. Fisher does and is the planning director, and that's where the buck stops on those interpretations. The opponents have repeatedly talked about trying to work their way around the mootness issue. They have tried to say that, well, even though that application for a 257-acre property, whatever it was withdrawn, we should still have everyone listen to our appeal and make a decision. And they say, well, this issue can be repeated and review can be evaded if they don't get a chance to have their appeal decided now. Well, that's not true. As Mr. Ashburner commented, the common practice of these type of proceedings is that whatever the administrator decides, the application then goes on to be decided by the relevant board, the BZA, Planning Commission, or whoever, on the merits. And people who oppose that application get to raise any argument under the sun when the application is being heard on the merits. They could do this with Mr. Ryan's interpretation, and then you have proper exhaustion of remedies. What we've described here today about this piecemeal approach is just, it's interlocutory. It's not what's commonly done. I don't think it's consistent with Kentucky law or with the intent of KRS 100-261, because otherwise you are going to open the floodgates of these type of appeals. But all of these appellants here, Mr. Grady, Mr. Houchins, Mr. Strobo, they have the ability to address the issues they want to address in the conditional use proceeding on the merits on the new application. It is ridiculous that they are wasting everyone's time with an appeal of something that is moot and that is untimely. And I also noticed they have never really responded, the appellants have not, to the concept of being injured or aggrieved. And there's serious case law on that, appellate case law, the Meitzen case, which I cite in my filed memo, and also the City of Prospect case that just became final with the Supreme Court. It talks about the importance of injury or aggrievement. There is no way that people who are raising an issue with a withdrawn application are injured or aggrieved. And so just on that basis alone, the application should be denied. A couple of points raised in the appeal. I noticed Mr. Houchin several times cited KRS 100-271 about not making literal interpretations. That only applies to building permits. That's where, admittedly, Mr. Ryan has very narrow discretion in building permits. This interpretation is not governed by that statute. And we have over and over people today trying to address the merits of whether a data center is a good thing or a bad thing. That's to be decided in the conditional use permit process. And there's a continuing implication that Mr. Fisher gave sort of a carte blanche by this interpretation to these data centers. He did nothing of the sort. Making it a private utility, which falls under conditional use permit authority, puts that land use under potentially very strict regulation. I have seen numerous CUP proceedings where the end result is page after page of conditions imposed on the applicant for their conditional use permit. So there's no carte blanche for data centers in Mr. Fisher's interpretation. He looked at a category, made his interpretation, knowing that it would still provide adequate opportunity for regulation and for the benefit and safety of the Oldham County community. There were some issues raised here about references in the zoning ordinance, a reference besides private utilities of reserved. Well, that doesn't mean that that's an unauthorized use. It could mean a lot of things. One thing it could mean is that this is reserved for in the future detailed regulation. And, it may be that the fiscal court does that in the future, but it doesn't mean that he couldn't designate something as a private utility. In fact, as Mr. Ashburner said, he talked about that case on Dawkins Road. There was previously a private utility case. I've got the docket number. It's OC-23-040, and I will incorporate the record of that case into this proceeding. It was in November 23, but the BZA applied the private utility concept to that case in a CUP. So it's not a concept that is non-existent. It's something that has been applied before by this BZA, and we have Mr. Fisher. Just ultimately, when you step back at it, he has to do the best he can with an interpretation. He did that in a reasonable, rational basis and non-arbitrary manner. And that should not be overturned gratuitously or just because there's a crowd in this room. Look at his interpretation and his authority, and is that interpretation arbitrary? It was certainly not. So what we would ultimately ask is, on all the grounds that we've talked about today, we would ask that these appeals not be sustained on the timeliness issue, on the mootness issue, on the aggrievement issue, and on the merits of the definitions. Ultimately, your planner made a decision under your regulations, and the merits issues about CUPs, about data centers, whether they're good for the community, that can be addressed later fully in the CUP process. Now is not the time of that. Please reject the appeals. Thank you.
Okay. Rebuttal by Appellate Houchins. 15 minutes. Hang on, Rob. Okay, whenever you're ready.
So arguing in a rebuttal phase is, again, something I've never done, so bear with me as I go through this because, like I said, I'm not an attorney, but I'll do my best. When we talk about what happened and when the timing was and when I knew about it, I heard about it back when Mr. Ashburner said I knew. It's clear. It was it was up there. But what's that have to do with what we're talking about? We're talking about when the conditional use was filed, and secondarily, only during an open records request do we now know that it wasn't even paid for at that time. It was later. Follow the money, and I will show you that. I may have the overhead, please. March 19th is when I heard that we were going to use a conditional use permit.
Hang on, Rob. Hang on. It's not on our screen yet. We just got it on our screen.
Come on, make that a little faster
I know,
there, Larry.
I know. All right, go ahead.
Secondarily, there's nowhere on this, even though this application was taken, there's no date put at the top. The staff didn't do what the staff was supposed to do, and if it'd be on here, we wouldn't even be having this discussion today. Secondarily, we need to have a place put on here so where the payment is shown and how much was paid, how was it paid, and what date was it paid on. Because when you follow the money, you'll find out that we were well within our time frames of what we were supposed to do. And to take an application without the filing fee, I couldn't file my appeal without it. Additionally, it was argued a few minutes ago that arbitrary is the standard. It's not about arbitrary. I put the standards up in front of you guys. I read what the standards are for a planning director, and I can pull it out again, but I've shown you exactly what the standard is there to be held to. The argument is that he's went beyond his scope. It must be specifically defined. We can put all kinds of other fancy words, and we can talk about what the best category is. Again, I fall back on my original presentation. Also, the argument has said that, well, we have these other classifications that we kind of use something else to make this go through, and that's how we did it. I don't know about you, but if I drove down the road at 50 miles an hour over the speed limit every day, and I go it day after day after day, and then one day I get pulled over, guess what? If I look at that police officer and I say, but sir, I've done this wrong for a month. Let me off because you didn't catch me on the other days is a ridiculous argument on its face. Literal terms. Let me point out one more thing. The reason I am here, and we can say that it should be thrown out because it's moot, but here's the argument. I'm arguing with this case, and we're trying to throw it out because they pulled it. They don't want to be heard. And here's why. We now have 3210 Griffith Lane, and that application now is what I will file on again today or tomorrow if we don't hear this through to its conclusion. So that's what I will file on again if I must. If you can by somehow believe that we shouldn't be heard and you should throw out our case, I will file, and I promise you I'll be within my standards. Here's what I know. That is a time that we can hear it today, or we can hear it later, and we can come back here and do it all over again. But I promise you we're going to go through the same steps and the same processes. Now, the lawyers may have time because they do this as their full-time job. By the way, I have another job. But what we will do is we'll come back and we'll find them and we'll hear it again. Here's what I know. When I was on the Board of Adjustments, short story, but this is the best way I know to argue it. I was sitting here and Larry was on the board as well. Someone came to before the board. They had a home. They had a garage. They were 20 feet apart. And they took a brick and they made a wall between the two with a bunch of bricks. It was this wide. And Mr. Urbans decided that it was a breezeway. Even though the path through didn't lead you to either building, it was 20 feet apart. At that point, Larry wasn't the chairman, but the chairman at the time then used this argument, and he said, Mr. Urban, here's what I know. If I follow your logic through to its conclusion, then and you're going to allow them to put another building out here, because you guys know the rules, I'm sure you do, about how you put in an additional garage on a property. And as long as I take bricks and connect them sideways, one to the other, to the other, to the other, I can eventually build a whole castle with the turrets being where the places where the garages are. And I could go completely around and round. Jim didn't like it. By the way, I think he was upset with me for a little bit of time, because next month, I think I got a little bit of the cold shoulder. But the argument on its face caused a consequence that could happen. The argument today is if you allow this to be an interpretation of, I'm going to use the best category. If I use the best category and don't follow the rules and don't follow the words like literal, then what happens, there's a consequence to that. And that consequence is very clearly that more will be filed until that moratorium gets put in place. And they might even be filed after that, because once you say that we can use a conditional use permit, call it a private utility, if I'm a data center person, guess what I'm going to do? I'm going to try to find the easiest path possible. So my rebuttal is simple. Follow the rules, follow the path, follow the money, and thank you very much.
Okay, rebuttal by Jay, could you change the screen, please?
You're not going to clap for me.
Okay, 15 minutes for Appellate Lampton.
And Mr. Chair, if it's okay if I cross-examine Mr. Fisher?
Sure.
Okay. Morning, Mr. Fisher, or good afternoon. Now, I know you've been working hard on this. I know it's an issue that is a very difficult issue for you, and I appreciate all your work that you're putting into this. But I hope you realize that we're here to create this record, ask you questions about it, and that we have a professional kind of disagreement over that interpretation. So I'm just here trying to figure out what exactly happened. In the letter that your attorney submitted to this case, are you familiar with that letter?
Yeah, I believe so.
From Pike, from your attorneys, Pike Legal. I'm looking at footnote 2, and I'm going to read it to you, okay? The planning director's interpretation was not in the nature of a formal written document, but was instead verbal in response to an inquiry. That's on page 1 of the letter, if you guys are looking for it. So, when did you make this verbal response?
That was made at the February 10th, 2025 meeting that we had.
Meeting with who?
Cliff Ashburner, Jim Urban, and Anna Barge was in that meeting.
Okay, so you just kind of just said it, and that was, okay. Is, in your opinion, is that your determination that you made?
That was solely my determination that I made.
Okay. And did you do that in your personal capacity or official capacity?
My official capacity is zoning administrator for Oldham County.
Did you give notice of that determination or interpretation to anybody else outside of that meeting?
No.
Thank you. And do you consider that, and then this may be repeating myself, but I want to be clear, do you consider that an interpretation from you in your official capacity as a planning administrator?
Yes.
And as far as you know, did anybody refer to that determination specifically in their applications that have been filed, I would say from the developer for US Highway 53, or in the new application that was filed? Have they referred to that determination specifically?
I believe Mr. Ashburner's letter on March 19th with the initial one referred to the private utility designation as well as the letter for the new case.
But did it refer to your interpretation that you made in February at that meeting?
I guess it didn't specifically mention that, no.
Okay, thank you. Thank you, Ryan.
Thank you.
Okay, Mr. Ashburn or Cliff, I have some questions for you, probably you or maybe your client. Is your client here? I have the right to cross-examination, cross-examine their client. I think Cliff can serve in that capacity.
And yeah, if you want to come forward, and Cliff, and speak into the mic.
I provided a legal argument to the board. Typically, we do not allow cross-examination of a legal argument by another attorney. Okay. The only facts that I testified about were the previous case from 2023.
I just have a question about the application that I believe Mr. Ashburner filed on behalf of his client.
The application speaks for itself. The application speaks for itself.
Okay, Connor?
Does the board want my recommendation on that?
Yes.
I believe that the normal procedure of this board, and I think most planning and zoning boards, are that attorneys represent their clients, but attorneys themselves are not witnesses. I don't believe any of the attorneys here were sworn, took an oath as all the other witnesses have. It's unusual in the legal profession for attorneys to be cross-examined, especially in a matter in which they represent a client. And so I think that would apply equally here. If the Lambton appellants wanted a representative from WHP here to be subject to examination, I believe there are subpoena procedures that would have applied and allowed them to do that. To my knowledge, that did not occur. There's been no testimony by a WHP representative here this morning to cross-examine them about, other than Mr. Ashburner, who's not a witness. And so I don't believe that it would be appropriate to allow cross-examination of an attorney representing a party. I would say the same thing if Mr. Ashburner wanted to cross-examine any of the other attorneys who are here representing some of the appellants. So I don't think that's appropriate, and that would be my recommendation that it not. And I think that Mr. Ashburner makes a fair point regarding the application. If the question is about that, I believe the application likely does speak for itself.
Okay, thank you.
Yeah, maybe ask it. No.
Okay. We're going to go with legal recommendation.
Is that your recommendation
That is-
or your,
that's
is
the-
that your order?
that's
or
the
is that-
position.
Okay, thank you.
Luck.
And I still have some more. Thank you, Chair. I'd like to bring up Mr. Fitzgerald again. Mr. Fitzgerald, did you have a chance to listen to the testimony since you testified earlier today?
Yes, I have.
And do you have any rebuttal, any other opinion about that testimony?
Well, there are a few points I just wanted to make clear to the board. I appreciate this opportunity. The June 12th letter that was provided, I'm sorry, the June 12th letter that was provided justifying the decision that had been made classifying the data centers as a private utility cited two objective pieces of evidence in support. One was KRS 278.546, which was also mentioned by counsel today. That is a set of findings by the General Assembly that is wholly distinct from data centers. That is the justification provided by the General Assembly for why they decided not to impose rate and other regulation on broadband, which is a telecommunications rather than data centers. There is House Bill 8, which was enacted in 2024, which is the General Assembly's efforts to try to incentivize data centers in Kentucky with tax incentives of various kinds. And it does provide, in fact, tax incentives for data center equipment. If you look at the statute, which is codified, I believe, in KRS Chapter 154, was House Bill 8, is how it went through the General Assembly. It makes no mention to data centers being considered utilities, either private or public. And as the board knows, if it were a public utility we were talking about, we wouldn't be here, because under KRS 100.324, public utilities and their facilities are exempt from planning and zoning. The other point was a Department of Commerce press release, which was announcing an inquiry into how federal policy can support the growth of data centers, and says nothing about whether data centers are utilities. Counsel for Planning Director Fisher is right that this is a matter of my opinion, and to be taken as such, but it is interesting that in attempting to determine whether a data center is fairly interpreted to be a private utility, I did very much the same thing as the director did. He checked with the other planning directors around the state, and none of them considered data centers to be private utilities. I looked at all of the public service commissions and all of the legislatures around the nation, and none of them considered data centers to be utilities. So the information, and counsel for the director is correct that the question here on this determination that was made that data center is by law to be considered a private utility is a question. When you're looking at arbitrariness, the question is there substantial evidence to support the decision factually, but also is it in accordance with law? And what I've testified to is that as a matter of law, a data center does not fit within the definition of what a utility is, providing a service to the public on a non-discriminatory basis, typically with rate regulation and a geographic monopoly for a service area. I would note also that as a matter of substantial evidence on the factual record, the data center that's proposed here is proposed by a company that is listed in the Secretary of State's registry as a real estate firm. And it gives as its central address Bergenfield, New Jersey, which Google Maps will tell you is a house in a residential subdivision in Bergenfield. That to me suggests that this type of data center that's being proposed is not one that is a public utility or a private utility, but is in fact a co-location or a powered shell type of data center where the real estate developer, and there's nothing wrong with this is a method by which data centers are being developed, where a real estate firm will get all of the approvals and will get the connections for a potential data center, and then we'll flip the property to somebody else who will actually develop it. In all of those cases, whether it's hyperscale or it's co-location, powered shell, none of them are providing a service to the public. They are providing data services to a client who then is selling that service to the public. So appreciate your time. Happy to answer any questions that you have in terms of clarification.
Okay.
Thank you all.
I'd like to address one more issue on mootness, since it was brought up by both the attorney for the planning director and for the applicant, or Western Hospitality. So on the issue of mootness, and we heard that the first application was withdrawn, and We don't dispute that that first application was withdrawn. But in a Public Service Commission hearing last week that LG&E and KU testified to, and that is their COO, Lonnie Ballar, he stated that he was well aware that Western Hospitality withdrew their permit or their application for a conditional use permit here in Oldham County, but they did not withdraw their transmission service request. And a transmission service request is something that Western Hospitality will need from LG&E's transmission organization, which is kind of an independent body that decides when that big electricity user is able to connect to the grid. And that has not been withdrawn yet. So as far as whether or not Western Hospitality intends to refile, I think they still have the possibility of refiling for the same property under the same conditions. And if that is true, then this determination that Mr. Fisher just admitted that he made in his official capacity is not moot, because there's an opportunity to refile for that same property in the same location or a similar property under similar conditions. So with that, I would argue that mootness does not apply, and this case should not be dismissed. Thank you.
Okay. 15-minute rebuttal by Appellate Soberg, Oberg. We are Oldham County.
Chairman, point of order.
Yep.
One, again, wants to place my objection on the record.
Okay. Speaking to the mic.
We've got WH. And again, wants to put my objection on the record that here we are talking about WHP, and then we have somebody up here giving their arguments and their testimony, but they cannot be cross-examined, so they're not properly represented here. So here we are giving, again, 20 minutes, rebuttals, all this time to two different entities, and one of them can't even be cross-examined. So I object to the fact that they're not here.
Okay.
Again, I'm Hank Grady, back for rebuttal for the Obergs and for We Are Oldham County, and I don't think I will need 15 minutes. I do want to emphasize a point that Mr. Fitzgerald made when Mr. Fisher was describing his due diligence. He described a process of contacting planning officials across Kentucky. And I think you heard Mr. Fitzgerald say what the results of that investigation were. Mr. Fisher showed the emails from across Kentucky. Not one of them used private utility as a basis to place a data center. So his search of other planners across Kentucky should have been a warning not to go in that direction. His attorney, Mr. Brown, said he was entitled to a reasonable interpretation. And the test that you all have to apply was he arbitrary? Again, Mr. Fitzgerald stated this, but I would like to emphasize a official is arbitrary when he or she acts in excess of the limits of the law. The law determines the boundaries of official action. And when the law says a conditional use is a use that is specifically enumerated, that is the boundary. And that is the boundary that applies to Mr. Fisher and to every person who is considering a conditional use application across Kentucky. They must find a specific identification of that use, and there's no question that is not present here. I think it's telling that at the same time we are here debating whether this can be squeezed into private utility, a term that I believe is not properly authorized for use. Perhaps it has been used, but I would say that was error because I believe that your legislature has not authorized it. But at the same time, we're considering whether to squeeze a data center, I believe improperly, into the meaning of private utility. This community is considering a zoning ordinance amendment for a data center that does not use the term private utility. Doesn't need to. That is the way this community should go. This board should support that process by granting these appeals and finding that the February 10th decision that Mr. Fisher made in the presence of Mr. Ashburner to allow it to squeeze in was in violation of statute, in violation of good planning principles, and you should set it aside. That's what we ask you to do. I want to take you back to Mr. Ashburner's presentation, where he is trying to assert that the measuring date starts in March or April. He does that by asking you to look at a web page that asserts, my client asserts, that as far as we can tell, they, the developers, Western Hospitality, are trying to make it seem as a private utility. That's what we were afraid of. We thought they were going to try to get approval for that definition. We didn't know what Planning Commission would do with it. We weren't aware of the February 10th conversation. We weren't party to that meeting. Mr. Fisher acknowledges no one knew about it except the three people in the meeting. We learned about it when we saw an application for a TRC proceeding, but that's not the one that we were waiting for. We were waiting for the conditional use application, and that was filed and the fee paid on May 1st. That is the one we discovered by open records, and that is the one that triggers our obligation to file an appeal. We filed the appeal May 19th, 19 days later, after notice of the conditional use application and the paying the fee, just as Lambton did and as Mr. Houchins had already filed his appeal on May 1st. But the argument that this is untimely is an argument that I ask you to reject that argument, and notice that Mr. Ashburner continues to refer to the date of the application, the date of the application. The application is not the issue. The issue is, when did Ryan Fisher determine that the application could go forward? Now, I agree with Mr. Ashburner's, a part of his analysis. He said the way this normally works is you learn that the determination has been made when a hearing is scheduled. And sure enough, a TRC hearing got scheduled, and and we were expecting a CUP date. We thought at that time it might be today, but at that point we knew that the determination had been made sometime. We didn't know it was made February 10th until moments ago. That is the first time we have learned that. But surely they're not going to argue that we had 30 days from February 10th. We had 30 days from when the conditional use application was applied for, the application was complete and accepted, and a hearing date was scheduled. I would ask you to reject the untimeliness argument advanced. And I would ask you to also reject the mootness argument. We know this is an issue capable of repetition, yet avoiding review. And as Mr. Strobo indicated, the prospect that the 53 property may come back before us is real. We know that they are not putting 8 buildings on the drive-in property, only 2. But they still have held on to the capacity for 8 buildings. So they are looking to put 8 buildings somewhere in the county, as far as we can tell. And we believe that this is the time and the place to decide whether the private utility loophole is going to be abused this way. We would ask you to find that this is a real and actual controversy in front of you, and your decision will have impact both on a withdrawn application that might come back, but it'll also impact a pending application that's going to be coming to you shortly, unless it too is withdrawn and this applicant decides to follow the law regarding data centers once that law is in place in this community. Thank you very much.
Okay, 15-minute rebuttal by Western Hospitality.
Again, I'm going to try to be efficient with everybody's time. Thank you, Mr. Chairman, members of the board. Mr. Houchin just testified he became aware of the application on March 19th. So those were his words to this board. If you become aware of an application on March 19th, you have actual notice of what's happening. And if you have actual notice, it doesn't matter whether you get notice in the mail later or you see it on the website, you have actual notice. That was the day he was on the clock. His appeal was filed 40-some days later, 42 days later, outside of the appeal window. I showed you the information from Mr. Oberg's Facebook page that he created and has been a prolific poster on that showed he had knowledge of private utility being the method that this application was using as of probably earlier than April 5th, but at least on April 5th, he acknowledged in writing that he had that information. Again, his appeal then is 44 days, not 30. So, I don't know when Ms. Lampton learned about this initially, so I don't really have much to say about that. When it comes to the determination that you all are going to make, I think it is important to, understand, did Ryan exceed his authority in accepting an application? Because that's what was referred to in the appeals. It was the acceptance of that application that was the official action from which they appealed, and that Ryan exceeded his authority in doing so. I think Mr. Turner, Member Turner, you asked a very good question early in today's proceeding, which is, if it's not a private utility, is there something else? Is there another law? And I think, Mr. Allen, you asked a similar question early in the presentation. And the response was, no, there is nothing. There is no regulation. There's no law that would apply to this. This is not a situation where Mr. Fisher, called a car wash a store, or called something that was otherwise defined something else. This was a situation where he exercised his discretion as the planning administrator and said, looking at the characteristics of this proposed use and the definitions that we have in our ordinance, these line up, therefore I will accept the application. You all have seen cases like this over and over and over again, where Mr. Fisher has made, or his predecessor, whoever is the planning administrator at the time, has made a determination that based on the characteristics of a proposed use and a definition that is aligned in or set out in the comprehensive zoning ordinance, those two things align enough for the application to proceed. And you've heard those cases and decided those cases on the merits. I think that is the result you should reach today. I do think that the timeliness and mootness arguments are sufficient for you all to dismiss the appeals without even having to get into whether Ryan had the authority to accept the application, although I do believe that he did. Thank you.
Okay, thank you. Okay, final statements. 5 minutes for each. No new testimony, starting with the planning director.
Mr. Chairman, Keith Brown again here for Director Fisher. I'll try to be pretty brief. I think all the issues here have been hashed and rehashed and articulated. I do want to mention that I do agree with the determination of the importance of actual notice, and we do adopt Anna Bard's arguments and her statements as to the timing of these issues. And we think there is an untimeliness issue of these appeals that remain. The mootness issue remains, and the overarching issue of was the decision arbitrary remains. And I do not think it was arbitrary. We've seen how Mr. Fisher made his decision. How other people would have made the decision is not really relevant. it was interesting to hear the testimony of Mr. Fitzgerald, who's certainly a well-known attorney. But I would encourage you to just take that testimony as just more attorney argument. I mean, there's no evidentiary basis that would result in overturning Mr. Ryan's decision. He's just another attorney making more argument about how he views the statutes. I disagree with him on 278-546. That shows a clear legislative indication of the importance of telecommunications. Data centers are completely tied into telecommunications and the internet. So I think that evidence of the importance of these centers and how that ties into the definition of private utility is important. Mr. Grady also talked about how these appeals normally work. Attorneys who practice in land use know that piecemeal interlocutory appeals are not common. What happens when a decision is made on an application is that the application moves forward to decision on the merits. If anyone has any jurisdictional issues or definitional issues, they raise them on the board, to the board during the hearing, or they raise them to circuit court later if they properly preserve them. So that goes to the heart of my argument that this opens a whole Pandora box of these administrative appeals. No evidence of arbitrary conduct, mootness, all the other issues. And with all of that, I ask that the appeals not be sustained and they be denied and they be dismissed as moot and untimely. Thank you.
Thank you. WHP, 5 minutes, final statement. Thank you. Appellate Houchins, 5 minutes. No new testimony?
I will be using the overhead, so can you turn that on,
Will
please?
be. Jay, can you get, thank you.
Can you see it yet?
No.
Okay. We're burning my time, but I may not need it all.
Go ahead and stop the clock, please. Reset it. And I think we have it now.
You have it now?
Yeah.
Thank you. Gentlemen, you've heard an awful lot today. I'm going to go back to where I started. Yes. That is, the administrator does not conform to the literal terms of the zoning regulation. You cannot do it. This is very simple. And again, I'll point out, based on open records, I guarantee you I was timely. So what I would like to say is that there are a few things that could happen as we go down this road. So if you guys happen to find that our appeals are not valid, the next thing you're going to do is you're going to hear conditional use permit application. And in that conditional use permit, we're going to go back to this. A blank sheet of paper. And now all of you are going to have to do a couple of things. You're going to have to say it's consistent with our comprehensive plan. Can't. And additionally, here's the big one. And I can tell you, I would not consider myself an expert, but in this room, I might be in the top 2 or 3. And here's what I'm talking about. What are the restrictions? When you guys grant some of these things, you have to put conditions on them. Are you going to know how tall, how big, how much diesel storage? Are you going to know about what kind of decibel level? So when you hear the next conditional use permit, if you happen to say our appeals aren't valid, what you're going to have to rule on is you're going to have to rule on that it's consistent with the comprehensive plan, and you're going to have to become experts really quickly because you're going to have to put those restrictions in your motion. That's what you do. So on its face, that doesn't make sense. That's why the appeals are relevant. This isn't personal. I've never seen Ryan Fisher do anything but act professional around me. I've not after Mr. Ryan Fisher's job. Tomorrow, he'll be in his office, whether we hear this appeal one way or the other. This is about that he made a mistake. Now, whether he was pressured to make that mistake or whether he's not, I have no idea. Here's what I know. Follow the rules, follow the process. What I'm looking for you to do is to protect me, protect them, and protect Oldham County. Thank you.
Okay, 5 minutes, yeah?
Thank you, Mr. Chair and the board. I'd also like to thank all the staff and everybody that put all the work into bringing this case today and trying to figure out these issues. It's a difficult issue, and it's hard work, and it's all very appreciated. This appeal was timely, and it's not moot. You heard from Mr. Ashburner. He had no argument to say that my client did not receive notice at the time she received it. She received it in early May. We appealed shortly thereafter, within the 30 days. It was timely. It also is not moot. We've entered into evidence and argued that this determination could be used again at for another application, for another proposed conditional use, and that the original applicant, Western Hospitality, could reapply at any time for the same property under the same conditions as a private utility conditional use. And not surprised, well, maybe surprisingly, the client didn't even show up to rebut that. They're hiding behind their attorney, and the client didn't even bother to come here today. Allowing a determination to stand when there is no specifically named data center use in Oldham County, we went over that. I think everybody agrees that the data center use is not specifically named here in Oldham County. And when the private utility use has never been developed in Oldham County, as Mr. Grady argued, as long as myself, and when a data center is not defined as a utility in any other forum across the state, as we heard from Mr. Fisher about that in his emails to his fellow planning directors, and as we heard from Mr. Fitzgerald from his inquiry of planning directors and Public Service Commission officials, nowhere across the state of Kentucky, or Mr. Fitzgerald found nowhere nationally where a utility or a data center is considered a utility. And as Mr. Fitzgerald testified, that a data center is not even a telecommunications utility, and verified that with the PSC director herself. So altogether, the determination by Mr. Fisher, as he admitted that it was a determination, is arbitrary and unlawful, and we request that you find any such determination to be an error. Thank you.
Okay. 5 minutes.
Thank you, Mr. Chairman. I too want to express my appreciation to the members of the board for your patient attention to this matter. It has been a long morning and into the afternoon, and I and my clients are grateful to you for your consideration. Mr. Ashburner said one part of his argument was something I agree with, and I want to call that out. He said that you don't litigate against concepts, against perceived rights or wrongs unattached to a specific case. And I agree with him. In our situation, we were looking for a decision, not that he had filed an application, but that the application had been cleared to go forward as it was applied for. And so we determined that our measuring date to challenge the determination that the application is ready for a hearing was along the time that it was scheduled to proceed forward because it had been accepted by the planning director. We have stated in our application, our appeal to you, that we learned that on May 1st, in response to an open records request and publication of the conditional use application and the paying the fees. Now,
we challenged this. Mr. Heath Brown complained about interlocutory orders. And I want to respond to that. Generally, I agree with that concept. The law does not look forward to appealing piecemeal, but it has been my experience, and I've learned it the hard way, that if I do not challenge a decision by a zoning administrator, as soon as I learn of that decision, then I have lost the opportunity to challenge that at a later date. And that must be in the context of a specific case. In this case, there was an application filed, a TRC hearing scheduled, I think in April. All of that was withdrawn, and we recited that in our petition. And then there was an application for reapplication for TRC, moved from April to May, and an application for a conditional use permit. And those were on or about May 1st. So our application was timely. We had to challenge it now because KRS 100-261 gives us 30 days. KRS 257, 100-257 gives us 30 days to challenge a decision by the zoning administrator when we learned about it. And we learned about it today. This is the first time we have heard the date of that decision. So, but we knew it had happened, and we filed as soon as we knew that it had happened. I would ask you to find that we acted as quickly as we could in order to protect our clients and our opportunity to challenge what we thought was a bad decision, a decision to proceed this way as opposed to the correct way, and that is amend the zoning ordinance, define the use, and then go forward according to a zoning ordinance that covers this particular use. That is the opportunity that's in front of you if you grant our appeal and require this applicant to start over and follow the law that is coming soon to address this issue in this county. That's what we ask you to do. I was trying to think, is there anything that Mr. Brown said that I could agree with? But I don't think there is. So thank you very much.
Nathan Oberg, 1414 Yeager Lane. We can't have it both ways. We can't call this a private utility while actively looking for a definition of a data center. It's either one or the other.
Hang on. Okay, so first of all, I don't know, did you ever get sworn in, and there's no new testimony at this point?
Okay. Thank you for your time.
Thank you. Okay. Board members, questions by board to anybody in the audience?
Mr. Fisher, could I? Does your position give you the authority to just outright deny any application that is coming to the board?
Repeat that question again.
Does the position you're in, zoning administrator, does that give you the authority to say that someone who's paid the application fee for the application, can you say, no, this can't go before the board for interpretation?
Has that ever happened since I've worked here? The answer would be no.
Okay.
Could you have somebody come in and say, I want to do this in C1 commercial area when it's only allowed in C3? I could say, no, you're going to have to get a zoning change and tell them that process that they would have to go through in order to.
But that case would be specifically excluded from use, like in the technical documentation.
Correct.
Okay.
I have a question for either Ryan or Anna. I'm not sure who. So I'm just trying to get the timeline documented and straight in my mind. So we have the application that was issued March 19th, 2025. And then I also have in front of me here the application for technical review committee, which has the same date, March 19th, 2025. And this one has a stamp on it for $550 that was paid with the application for technical review. And then, of course, we got the notice in the Oldham County Planning website, March 31st. So with respect to the first thing, the initial application, I forgot who presented an overhead with no date and no money marked on the application. And there's been allegations that the money wasn't paid timely, so the application's not effective. Can you talk about the timeliness of that application and the money?
Yeah, so that application was dropped off, I believe it was on like a Friday or something, but they did actually submit a check with that application. However, the check was for too much money, and so I emailed them and got the proper amount, and there's documentation, and I know somebody in this room received that through the open records request they submitted. I included that. So that's where that letter is, and and that's for the conditional use permit, and since it's going through the appeals process, we aren't going to, deposit the check if it's potentially not allowed to go through. So that's why it has not been deposited yet. But they did send us a corrected check for the correct amount, and we returned the check that was too large in amount.
And so that check, there's $550 with this technical review committee on
Yes.
March 19th.
That was paid, yes.
Both at the same time then, or how?
No, so the technical review committee application was submitted on March 19th, and then, hold on, let me go back to my notes. I'm trying to remember, I said that I think it was later, but yeah, the Board of Adjustments application was submitted at a subsequent date in early April, I believe.
Okay. All right.
Anna, when was this application withdrawn?
It was withdrawn, I have it in there, I think it was June 2nd. So yeah, it was June 2nd.
That's okay, June 2nd.
And we also, that same week, posted all the new applications on our website, which is not typical part of our process, but, in efforts of transparency, all of their documents, including their withdrawal letter, is on our website. So typically when we receive applications, we have a deadline. I believe it's the third Wednesday of the month. Second to last Wednesday of the month. And sometimes that's before planning commission and stuff like that. So when we start processing them is after usually the last meeting of the month, which is planning commission, which is the fourth Tuesday of the month. And then we create our agendas. And then we put the agendas on the website. We start doing the mailings, and we put the applications on our website. So that's the process that we follow.
All right. So June 2nd, this was removed. It was put on the website as being removed. And you say the new one was put on, all the other applications were also put on June 2nd. The new application for Griffith.
Well, so the CUP application wasn't put for the Highway 53 location, wasn't put on the website, and that's because it hadn't been assigned a docket number. It never made it to an agenda because we first had technical review committee, and then it would have come to the agenda today had there not been appeals filed. So those appeals take precedence, and those go first, and then at a later time would have been when the CUP for the Highway 53 location would have been considered. However, they withdrew that application, so that's no longer being considered.
Any other questions for anybody in the audience?
So I just have one more question. So we've had applications withdrawn before, and they never come to us, right?
Correct.
So, and this one would not come to us because it's been withdrawn, right?
Correct.
So how does the appeal process fit into that timeline then?
What do you mean? I'm kind of
what we're
confused
talking about today. I mean, the
So, yeah,
application
there-
was withdrawn.
Yeah, well-
So what are we appealing?
Exactly. That's a good question, because you're appealing, I guess, a decision that hasn't been made. Usually
Hasn't been made.
usually, the board would decide something if somebody wanted to appeal that, the board or planning commission, and I believe that would be through circuit court if someone appealed the decision that the board made.
Yes, generally.
Okay,
Yes.
so like for example, somebody appealed a decision at planning commission for a subdivision that went through circuit, or is going through circuit court, I guess. So usually it's after a decision has been made. I don't think we've ever received an application for an appeal before the board or the commission has made a decision. This is highly unusual.
If I may
Yeah.
add a little bit of clarification on that, what we are here for is a kind of a different type of proceeding than I think this board is used to hearing. This is an appeal, and the statute that governs, we've looked at a little bit today, is KRS 100.261. And what that statute does is it requires the board to hear appeals of what we've called today administrative determinations. And so it's not a conditional use permit. And if an administrative determination has been made, there's a 30-day time period to appeal, but the appeal is of that specific administrative determination.
Okay, that's helpful. Now, I need to go back. So the question is the date of the administrative determination, right? So that's where the clock starts running, 30 days.
And
Is
just
that
to
right?
clarify, the statute, the 30 days begins to run from when the person who's filing the appeal has notice of the decision that's being appealed. Okay, and so you need to look at the applications here and ask yourself, what is being appealed? Reference the applications. That's what defines the scope of the proceeding before the board, is that appeal. And if you believe the appellant had notice 30 days before, more than 30 days before they filed the appeal of that decision, then it would be untimely. If you can't conclude that, or if you believe the opposite result, then presumptively it is timely. And then you would need to progress through the analysis of the arguments that have been presented this morning about mootness and then the merits.
So we can revisit that when we close the floor and then open it up for general discussion among board members. Do you have further questions for
No,
Anna?
I think I understand it all. Thank you very much, Anna.
Yeah, of course.
Any other questions for Anna or anybody else? Charles, you good?
I'm good.
Everybody good down here? Thank you, Anna. Okay, if no other questions, it's last chance. I'm going to close the floor. No other questions? Okay, I'm going to close the floor and open it up for general discussion among board members.
Well, again, the issue comes down to the timing of notice and mootness, given that it's been withdrawn, the application's been withdrawn. So the evidence that's been presented, both the comments on Oldham County's, the Facebook page that's been presented, as well as the postings to the planning and the website that Mr. Fisher's, Ryan's organization controls. So the question is, has notice been given? I mean, is it given and received? Obviously, when there's comments, public comments about the issue, they've been received, in my mind. So I don't know how you can refute that. I mean, if those comments weren't out there, then it would be questionable, but those comments are out there, and there's evidence that the public knows about it. So that's what I'm struggling with is how can you argue that notice has not been received?
Mr. Chair, if I may, I want to remind the board that while we have had a combined hearing on these appeals, they are three separate appeals. And so I think I would encourage the board to analyze them separately. And I think any motion that's made, we need separate motions on each of the appeals. As for the analysis that I think we just heard, again, I would encourage the board to look at each of the appeals that have been filed and consider the action that is being appealed, and scrutinize whether they had notice of that specific action more than 30 days before they filed their appeal, and think about the evidence that you've heard to that effect, and I would say make it specific to that, because that's what I think this requires. And so I would encourage you all to do that, and obviously flesh out the findings that you're going to make in regard to that. When it does come time for making a motion, I believe that if you reach the merits of the decision, I do think you need to make findings and a conclusion regarding the timeliness and regarding the mootness before you get to the merits. If you decide that it's not timely or if it's moot, then obviously you don't have to reach the merits. But if you're going to get to the merits, because we've heard arguments about timeliness and mootness, I would encourage you all to make conclusions about that as well.
Okay. Further discussion?
So the other question is what makes a case moot? When is something no longer relevant? I mean,
well, we would say that something is moot when there's not a live controversy about it anymore, and when a decision isn't going to have any practical effect or repercussion on the issue that brought it to the board. You heard Ms. Barge present about mootness, and frankly, that's my position as well, because, as I've said, the scope of the appeal is defined by the appeals that are filed. And as Ms. Barge explained to you all, the appeals all were pertaining to a Highway 53 site that has been withdrawn. And so I think you need to consider, you've heard arguments obviously against that, and I think you need to consider whether there is still any real controversy left to be decided by this board pertaining to an interpretation about a proposed data center at a location, the site for which has been withdrawn.
I guess the other thing that comes to my mind is if we were to deny this appeal, it's going to come to us again, right? Mm-hmm. I mean, with the next application for the Sauerbach site. So we're going to go through this whole thing all over again, unless we go through the four-step process of the SRC, planning and zoning, and fiscal court deciding, what is acceptable in terms of a data center. So, I mean, this isn't over. Even if we deny it, we're going to have this all over again with respect to the Sauerbach facility, unless they withdraw that one until we get our zoning regulations straightened out. Is that a fair statement?
I think that's an exact statement. Here's my perspective. So we've been here for several hours now. I agree with most positions. The fact that the original application has been withdrawn, the application no longer exists. A determination based on that application, I'm in total agreement that this is a moot point at this particular time. The determination is moot. The application doesn't exist. The application has been withdrawn. Therefore, the appeals are moot. The appeal is to the determination of an application that doesn't exist. That's moot. Totally agree that this will be back here at exactly what we're doing today for a new location. But for this particular 53 location, this particular application, this particular determination, and this particular appeal, I think this particular case, in my perspective, on one of five, is moot.
Well, I'm also hesitant to work through or make a determination based on the date issue, because what is notice? I mean, I've been involved in hundreds, if not thousands, of contracts. Every contract I've been involved in has a notice provision, and I'm pretty confident that notice has been adjudicated thousands of times in the courts. We have not. I think we've not had enough hard evidence and discussion of the definition of notice. We've talked about publishing in the Oldham era. We've talked about notice on the website. We've talked about the evidence of notice that people had because of postings on Facebook. That whole notice thing, it's still a gray area in my mind. I'm not convinced. It seems that most people have had notice, but I'm not sure exactly what the definition of notice is.
So I agree with you. However, again, going on the mootness based on a withdrawn application, the date thing is irrelevant to me.
I'll agree with that. My only problem is the fact that we're trying to determine the definition of a data center. until that is resolved, and it will be back.
We'll be back
That's
with
the
that.
merits
Yeah.
of the application, which we are not deciding upon today. We're deciding on an appeal to the decision.
So yeah, to me, it's
The
all
private utility
it's
has
all
been
moot.
withdrawn.
Yes.
And maybe I can clarify this by tying in some of the evidence that you all, or the arguments that you all heard this morning. There was discussion about you appeal decisions and not concepts. And I think there is a live concept and a live issue, and that's with regard to the general notion of, is a data center a conditional use under the zoning ordinance? That is the concept. The decision that brought the appeals to this board pertained to a decision to accept an application for a data center, the design for which I believe has been amended, at a site that no longer is being applied for. And so I think that's the distinction, is the concept versus the decision. And I would encourage you all to work through and think about that as you decide, is this timely, is this moot, and if you reject both of those, as you think about the merits.
Well, yeah, so the data center on Highway 53, which has been withdrawn, we haven't even thought about that or talked about it. We have not seen any details about it. It's
That application
there's
doesn't
nothing to
exist.
even talk about. I mean, that's the definition of moot, right? I mean, it does not exist.
Yeah.
So we can't even discuss the merits of that application.
No, it doesn't exist.
Now, I don't know if they filed another one for another application for the Sauerbach facility or not, but whenever that happens, the timeline will start, and then there will be times for people to appeal that. So, I don't want to go through this again, but I really don't want to go through this again.
Well, I think it's going to happen.
Unfortunately,
It's going to happen.
I mean, we've learned a lot going through this, right? So hopefully some of what we've learned will be helpful to make the next meeting shorter. But there's no application to even talk about.
Bound by the process. That we have to follow the process in the law in this case, and that
Yeah, that's right.
the muteness is, it's not there. And as far as timeliness, I think we did see direct evidence that at least two of the appeals knew about it greater than 30 days prior to, and like in the posts themselves. So we might consider one just, without the timeliness argument, but all three still have muteness.
Again, for a motion, we're going to need three motions, but I don't think we even, in my opinion, we don't need to bring up timeliness.
Yeah. Okay.
But that's my opinion.
Yeah, I agree, and it also would potentially set a precedent for notice for just about everything that comes forward beyond this. So I don't think we should be trying to adjudicate the definition of timely notice at this point in time, since that may be moot. So.
All right. Any further discussion?
I have a question.
All right.
I remember seeing when we were looking at that first contract, that first thing, everything kept the same address. The addresses had not been changed. So what kind of effect is that going to have? Even though the first one has gone away, the addresses for the 53 thing is still the same.
The 53 has been withdrawn. They'll need a new
But
application.
the address hasn't been changed.
You mean the applicant's address? Oh.
None of that's been changed. It's still got the same thing on the paperwork. Although the 53 address has been moved, although we can move on from 53, I thought we were looking at something else that was saying that it was still had the same address. They hadn't been changed yet.
Well, but it's
still referring to the 53 property.
It's a new application.
So again, we're not considering the merits of the data center on 53 or anywhere else at this point. What we are here to talk about is an appeal to an administrative decision as a private utility for a data center on an application that doesn't exist.
The application doesn't exist.
Any further discussion? If not, I'm ready for a motion.
And I'll remind the board, we need 3 separate motions, and as I'm sure you're accustomed to hearing, please explain the rationale for the motion that you make in support of the motion.
Do we need to take a quick break, or is somebody ready to make a motion, or do we want a short break just so we can
Get the language right.
get the language correct?
Yeah, I think we need to get the language
All right,
right.
so let's take, can I get a motion?
You can not meet after you go out. If you take a break, the board members cannot get together and say, okay, this is the language that we're going to come up with. Individual board members can take time and think through the language of a motion that they may want to present. And you can consult with me about that individually if you wish, but you can't have a meeting. That's where you get in trouble with the Open Meetings Act. But if you want to take a break to consider just to write down language and not discuss what you've heard and not
don't need a break. We
meet
just-
about
No,
it.
I don't think
Pause.
so.
Pause?
Pause,
No
yeah.
break, pause. I'm ready for a motion whenever somebody has one.
I'll make a motion that Oldham County Board of Adjustments Appeals deny the application for Oldham County 25020.
Mark, can you speak a little bit more into the mic, please?
I'll make a motion that we deny the request on Oldham County 25020 from Robert Houchkin for the appeal he has.
Can you explain the reasoning for the motion?
That the request has been denied for the application, for the site map has been denied.
Are you referencing the Highway 53
Yes,
site?
yes, and the fact that we need more definition on the what a data center is.
I'm a little unclear on the motion. So your motion is to deny the appeal of Robert Houchins
Yes.
because of what?
It's been withdrawn.
It's been the application has been withdrawn.
The underlying Highway 53
Yes.
application has
Yes.
been withdrawn.
Yes.
Okay.
And can we, can you address the, what the docket number is on that, please?
Oldham County 25020.
Should we discuss that?
Well, we can. Do we have a second on that? And then we'll go through discussion. Do I have a second on that?
May I just ask, is the basis of the motion that the application is moot?
Yes.
Thank you.
Yeah.
All right. All right, do we have a second on that? Discussion?
I just wanted to make sure that muteness was
yeah,
specifically
okay.
included.
All in favor signify by saying aye.
Aye.
Aye. Those opposed? Okay, OC 25020 has been denied. We need to continue with the other two. Anybody else want to make a motion on the other two?
I make a motion on an Oldham County docket, OC 25-21, that it be denied because the motion is moot.
And why do you believe it's moot?
It has been denied, it has been withdrawn.
In reference to the application for the Highway 53 site?
Yes.
Thank you. I'm sorry. I'm not trying to put words in your
No.
mouth. I just want to make sure we have an adequate motion for the record. Thank you.
Okay, we have a motion. Do we have a second?
Second.
Discussion? All in favor signify by saying aye. Aye.
Aye.
Those opposed? OC 25021 has been denied, and we have one more to go.
Make a motion that Oldham County docket number 025-020 be denied. 22, because the application was withdrawn and it is moot.
Can you clarify which application?
For Highway 53.
Thank you.
Okay. We have a motion. Do I have a second?
Second.
Discussion? All in favor signify by saying aye.
Aye.
Aye. Those opposed? All three have been denied. Ma'am? I can't answer that.
Hey, Larry.
Larry, are you going to recess for lunch?
Yeah, team, let's get a 30-minute recess, or?
Motion to adjourn for 30 minutes.
Well, unfortunately,
break?
we will see you again, yes.
Good.
Hey,
Yes, unless they change the.
board
zoning
members?
regulations. Yeah.
All right.
We have a motion for a 30-minute recess.
I'll second.
Thank you, Mark. Discussion?
Second.
All in favor signify by saying aye.
Aye.
Those opposed? Adjourn for 30 minutes. Please turn off the mics.